All right, good morning, everyone. Today is May 12th, 2021. This is a regular meeting of the members of the State Liquor Authority being conducted in Albany and also remotely. We have in attendance Chairman Bradley in the Albany offices, Commissioner Ford and Commissioner Fan attending by video. Staff in attendance, we have General Counsel Meyerhoff in the Albany offices. We have by telephone Deputy Commissioner of Licensing Roberts.
I'm on, thanks.
And myself, Secretary Donahue, also in the Albany offices. The next meetings of the authority next regular meetings will be May 26th, June 9th, June 23rd. Those are all Wednesdays. And just planning going forward in summer, we'll be on a slightly reduced schedule with a couple of 3-week breaks between some of the meetings. All right, Chairman Bradley, you have any announcements to make?
Tom, do we put, when you have the breaks up, did we put the dates on the website?
I have to check to see if the Public Information Office did that or not yet. The schedule has been finalized through September 1st, and when this meeting ends, I will check to make sure that the schedule through that time is up there so that the public knows what's going on.
All right, thanks. And then Gary has something, I think.
Yes, everybody should know that a new draft of our third-party provider advisory is being made available on our website today. It will be considered by the board a month from now, 4 weeks from now, at a regularly scheduled full board meeting, and parties will have the opportunity to respond with a written position, objection, protest, agreement, whatever, within 2 weeks. There will be instructions on the website where you'll be able to see the draft on where to send your written responses, if any, and the board will consider it 4 weeks from today. Also, I should say, whether you were in favor or against or whatever, the first draft of this document, which was out and considered back in the fall of 2019 or not, representatives and lawyers in the industry will probably want to see this because as currently drafted, it will create some obligations on licensees that fall into certain categories with respect to contracts they may already be in with third-party providers. So I recommend all licensees and operators at least read the final version, if not this version. Assuming there will be changes after the written comments, which I don't know. That'll be up to the board.
All right, then with that, we're going to proceed to the items on the calendar. The first item is 1283. This is a conditional no contest offer of forfeiture of the bond. Commissioner Fan, when you're ready.
I'm going to accept.
Commissioner Ford.
I'll accept.
Chairman Bradley.
All right.
I was gonna counter cancel and bond. I think to be consistent, this should be canceled because of the fact that it was a non-bona fide, and consistently we have canceled those licenses. It's clear that this licensee doesn't want the cancellation on his record, and I think it's important that it go there. But
Yeah, I misunderstood. I'm sorry. I'm voting for cancel and bond as well.
All right, then we have a counteroffer of cancellation and bond claim. Next item is 1284. This is a no contest plea, and just for your information, the license has been renewed through 2024. All right, then Commissioner Fan, when you're ready.
I'm at 3,000.
Commissioner Ford.
I'll do 3,000.
Chairman Bradley.
I will do 3,000 as well.
Next item is 1285. It's a conditional no contest offer of $2,000.
2,000 accept.
Commissioner Ford
2,000 accept.
and Chairman Bradley.
Accept.
Next item, 1286, it's a conditional offer of $1,500. Commissioner Fan,
Due to longevity, they've been licensed since 1995. Without adverse history, I will be willing to adjust this down to 1,000.
Commissioner Ford,
Same here, 1,000.
and Chairman Bradley.
1,000.
Next item, 1287, it's a conditional offer of $2,500.
Accept.
Commissioner Ford,
2,500 accept.
Chairman Bradley.
Accept.
1288, a $1,500 conditional offer.
1,500 accept.
Commissioner Ford
1,500 accept.
and Chairman Bradley.
Accept.
1289, a $5,000 conditional offer.
5,000 accept.
Commissioner Ford
5,000 accept.
and Chairman Bradley.
Accept.
1290, this is a no contest plea.
I'm at 3,000.
Commissioner Ford
I was at 2,000.
Chairman Bradley.
So 2,500, we can all agree?
Sure.
Sounds good.
$1291 is a $2,000 conditional offer.
Yeah,
And
just-
this
Sure.
this
I'm
licensee
sorry.
has this licensee has two other matters on the calendar, 1292 and 1293.
So can we take these in chronological order? I think that, to be fair, that's probably the best thing to do. Gary, do you have something you wanted to add?
That's all I was going to say. The first one in chronological order is 1292, actually, and it is a no contest.
All
Okay.
right, so we'll be taking 1292, then 1291, and then 1293. So first 1292, which is a no contest plea.
I'm at
Commissioner Fan,
1,500.
Commissioner Ford,
Excuse me, 1,500.
Chairman Bradley.
1,500.
Then we go back to 1291, which is the $2,000 conditional offer. Commissioner Fan, when you're ready.
I'm at 750.
Commissioner Ford,
I'm in accept their offer.
Chairman Bradley.
Accept.
Now we'll go to 1293, which is a no contest plea. Commissioner Fan, when you're ready.
I'm at 500.
Commissioner Ford,
1293. I'm going in a slightly different direction. I'm at 3,000.
Chairman Bradley.
3,000.
Next is 1294. This is a $2,500 conditional offer.
I'll accept.
Commissioner Ford,
Accept.
Chairman Bradley.
Accept.
1295 is a $1,500 conditional offer.
I'm going to accept.
Commissioner Ford,
Accept.
Chairman Bradley.
Accept.
1296 is a $1,500 conditional offer.
1,500 accept.
Commissioner
Accept.
Ford,
Accept.
Chairman Bradley.
Accept.
1297 is a $1,500 conditional offer.
I'll accept.
Commissioner Ford
Accept.
and Chairman Bradley.
Accept.
1298 is a $1,000 conditional offer. And this licensee has other charges with item 1300. So with respect to 1298,
I'll accept.
Commissioner Ford,
Accept.
Chairman Bradley.
I'll accept.
All right, 1299 is a default.
You don't want to do 1300?
I was gonna do that, just keep them in order.
Okay, 1500.
Commissioner Ford,
I'll do 1,500.
Chairman Bradley,
I had 2,000.
Actually, I'll change to Commissioner Bradley, Chairman Bradley, because I had 2,000 too.
all right, then now 1300, which is a $1,000 conditional offer.
I'll accept.
Commissioner Ford,
I don't think
I'll accept.
Chairman Bradley.
accept.
Next time is 1301. It's a no contest, it's a default, I'm sorry, to a non-bona fide charge.
Cancel and bond.
Commissioner Ford,
Cancel and bond.
Chairman Bradley.
Cancel and bond.
1302 is a $1,500 conditional offer.
1500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1303, a $1,500 conditional offer.
1500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1304 and 05. It's a conditional offer of cancellation and bond claim.
Cancel and bond.
Commissioner Ford,
Cancel and bond.
Chairman Bradley.
Cancel and bond.
1306, a $1,500 conditional offer.
Accept.
Commissioner Ford
Accept.
and Chairman Bradley.
Accept.
1307, it's a no contest plea.
I'm gonna take 1500.
Commissioner Ford,
I'll take 1,500.
Chairman Bradley.
1,500.
1308, a $1,500 conditional offer. Commissioner Fan, when you're ready.
I'll accept 1500.
Commissioner Ford,
Accept.
Chairman Bradley.
Accept.
1309 is a $1,500 conditional offer. Commissioner Fan,
Chairman, this is a no dancing charge from before COVID.
Right.
Where
It
were we-
was a year
Where,
and a half
where,
ago.
where were we on these before COVID?
I mean, if the application says, what I realize there's no cabaret law anymore in New York, but the application still says dancing or no dancing, and their application said no dancing.
Yeah, no, I'm asking like what fine level?
Oh, Tom, do you know the delegation for that?
There isn't a delegation for it.
Yeah, it's not. in
So it's
building.
it's probably 1,500 or two. It's whatever it would be for having a DJ. Probably
There's no delegation for that either.
no, probably, but we usually hit them. It's
1,000, 2,000,
Yeah,
1,500,
yeah.
2,000.
I would accept. It was a year and a half ago, and apparently they've been clean ever since, right? We don't have anything else?
correct.
Do you have anything else? I don't think so. All right, I'll accept 1500.
1,500 accept.
Chairman Bradley.
I'll accept.
1310 is a $1,500 conditional offer.
I'll accept.
Commissioner Ford,
Accept.
Chairman Bradley,
Accept.
1311, 12, and 13. It's a conditional offer cancellation and bond claim. This license was summarily suspended back in December.
Cancel and bond.
Commissioner Ford,
Cancel and bond, accept.
Chairman Bradley.
Accept.
Next item is 1314. This is a corporate change application.
So this applicant was denied a previous AX license because he didn't provide relief from civil disabilities for a criminal conviction. On this application, that relief from civil disabilities has been provided. I think that's the only holdback from the last denial.
All right, with that, Commissioner Fan, are you ready to vote?
Yes, now that he has a certificate of relief, I am going to vote in the affirmative to approve.
Commissioner Ford,
I vote to approve as well.
Chairman Bradley,
I vote to approve.
next item is 1315. This is a new package store application.
This is a new Nassau package store. It's 850 square feet. 800 of that will be retail, located in a shopping center. There are 2 protests. It's going to be a store with 0 employees. The applicant will manage. The applicant has no experience. He previously applied at this location and was denied for failure to comply. And the closest store is 0.1 miles away, and there are 4 stores within 1.7 miles.
All right, with that, Commissioner Fan, are you ready to vote?
So just the opposition also indicates that there are 20 stores within 2-mile radius, although I did not check that number.
Chairman, when you said that he was denied because of inability to meet the requirements, does that mean that he was approved and then he didn't meet the requirements?
I didn't. We'd have to double check that. It was either he didn't. Adam, do you know he either didn't answer licensing when they told him that he had an error on the application, or he got a conditional approval and didn't
Satisfy the conditions. So it was a conditional approval. He didn't satisfy the conditions.
Wait. We're on 1315, right?
correct.
Right.
Yes.
Right,
But this is a liquor store.
yeah.
They have conditions.
I'm just saying that, was it approved by full board?
It had to have been, yes. And then he has, once the approval goes out, they have conditions they have to fulfill just like any other applicant, and he failed to fulfill those conditions. I don't know what condition he failed to fulfill.
And what year was that?
2010.
2010, I see. Okay. Yeah, just the landscape has changed so much since then. All the neighboring stores are doing declining numbers even during this time, so I really don't see the public convenience for another store, so I'm voting to deny.
Commissioner Ford,
Yeah, closest store is right down the same road. And it didn't respond. The next 2 closest stores have declining sales. Only the furthest store has increasing numbers, and that's really just from what I call COVID 2020. Otherwise than that, I don't know. I just don't see the need for another store here at this point. So I vote to deny as well.
Chairman Bradley,
I vote to deny as well. Commissioner Fan's right. The landscape has changed in Nassau County significantly since 2010. there's no evidence that there's an increase in population. For all evidence actually points to that it's a stagnant population. The applicant gives no evidence of products or services they're going to supply that their closest stores aren't supplying already. And based on the sales numbers, as Commissioner Ford pointed out, it's clear that the demand for alcohol in that area is already being met. So I don't see any public convenience and advantage.
Right, then the next item is 1316. This is a new on-premises liquor license application that was subject to the 500-foot law.
So this is going to be a restaurant with 8 employees, no security, and the principals will manage recorded music only, no dancing or promoters. The max occupancy is 35 people, table seating for 10, 5 seats also at the bar. They will also have a sidewalk cafe with 25 seats. The hours that they indicated will be close at 11 p.m. Monday through Wednesday, 12 a.m. Thursday through Sunday. The outside doors will shut at 10 p.m. 2 area residents object to the application because of the applicant's behavior during the COVID period at another licensed premise on Hudson Street in Manhattan. They said the place on Hudson Street was basically a nightmare and that they were not complying with any of the COVID EO executive order obligations. Our information on that is that we basically have one complaint, which is turned into a pending enforcement matter, which I believe there is a CNC on today for that. 2 principals of the applicant hold license that has that pending disciplinary related to COVID-19. The opposition also indicates there are 65 licenses within 750 feet, and 26 within 500 feet. We didn't really get anything from the community board on this license, although all indications are that they oppose it strongly. And the ALJ found at the 500-foot hearing that there is no public interest. Gary, do you want to add anything to that?
Chairman, there is in the supplemental, there's a letter from the community board.
Okay.
Dated
My
from
bad.
November.
Yeah, I don't have that either. Is it opposing?
Yes.
Yes.
Okay. Yeah, the only thing I was going to add is that there appears to be a disconnect between the complaints of the neighbors and the referrals we received, because we don't have a referral. We were in that neighborhood all summer and in the fall and through the winter, and we don't have any other referrals of issues with the location that these applicants also own since June 10th. So since on-premises services was permitted in New York City, we have no complaints in our records.
Which does not mean that did not happen, for the record, but we don't have any indication about it. Also, the location was previously licensed as an eating place beer, and then after that as a restaurant wine with no adverse history.
All right, so with that, Commissioner Fan, are you ready to vote?
Well, I really believe that this restaurant is just a restaurant. The 500-foot hearing came out in the negative, and we have a letter from the community board objecting, so I don't. And this location has no doors, and it seems to be a place that could overflow onto the street, so I just don't see how I can say yes. The community is really, really against it, and I don't have any information from the licensee saying that they're not doing what is claimed here, so I'm gonna vote to deny.
All right, Commissioner Ford, your vote, please.
I think a lot of the objections are to do with the other other licensed premises. Is that correct, Gary? Would you say?
Yeah. So with respect to the character and fitness issues, the whether these operators are were doing the right thing, it's with respect to the other place, but there are also in play public convenience and advantage issues related to the number of locations and the community's opposition that are also for the board to consider.
Do we know what the other EO violations at these other places were? I mean, how serious were they?
Yeah, the other case, the case that's actually on for today, which wasn't resolved for many months, concerned serving outside with a bar. When New York City was doing to-go service back in May, June, where the executive orders restricted people mingling out in front of a location. So I think there might have been two incidents that involved that we have complaints of, and we have, but that does date back to before on-premises service was permitted in New York during COVID.
Okay. I thought their public interest statement was kind of weak. And I'm going to agree with the ALJ that they've not met the burden, so I'm going to vote to deny as well.
All right, Chairman Bradley.
So just so everyone's clear, I do have the community board letter here, and as I expected, it does show strong opposition. I too don't find their public interest statement gives any support for the public interest. They don't indicate it's a unique dining experience. They don't talk about any of the factors that legally we are required by law to examine. This, I don't know if it was an OP license previously, but it certainly hasn't been an OP license in the last decade. It was previously an RW, and prior to that, an eating place beer. There are a significant number of licenses within 500 feet, as the community board pointed out, and I just don't see any public interest in adding another license in this neighborhood that has a significant number of licenses already. So I'm going to agree with the community board and the ALJ and deny.
All right, the next item is 1317. This is an on-premises liquor license. It's a transfer that was subject to the 500-foot law.
Go ahead.
Tavern with 20 employees, 2 to 4 security guards, a principal to manage with a hired manager as well, recorded DJ and live music, as well as dancing and pool table. Will close for private events occasionally. Max occupancy is 279, 18 tables with seats for 103 people, 16 seats at 2 separate customer bars, no outdoor space. The ALJ in the 500-foot hearing said no public interest. The community board recommends denial of the transfer strongly. There are 2 residents who support the application. Their hours are 4 to 2 a.m. Monday through Wednesday, 12 to 4 a.m. on Saturday, and 12 to 2 a.m. on Sunday, and then 4 to 4 Thursday and Friday. There are residents that live above the applicant in the same building. There are 26 between, I didn't get an accurate number, but there's definitely between 26 to 28 on-premise licensees within 500 feet. The location does have an adverse history. We canceled the previous license here. Also, the most recent licensee also had adverse history, including focal point and disorder charges. They have changed some of their method of operation once they got the community board recommendation of denial, and they have dropped the DJ. No, I'm sorry, they dropped live music and jukebox. They've also said they will not retain a promoter or permit karaoke on the premise, and they've also cut back somewhat on their hours, but not significantly.
Yeah. Also note this is a transfer, and while a prior licensee was canceled, that was in 2014, and then that was the most immediate prior licensee did have adverse discipline. That goes back, I think, to 2016. So in the last 5 years, the place has operated with a method of operation that's arguably louder than the one that's currently being proposed, and we don't have any complaints. And the community board vote was nearly a tie vote.
All right, so with that, Commissioner Fan, are you ready to vote?
Yes, given the letters from the neighbors saying that they're open already and they like this new addition, and what council mentioned, there's essentially a tie vote at the community board level, and that this location was licensed before and we don't really have a lot of negative on it. And I find the licensee's council's letter helpful and convincing. And with that, I'm going to vote to approve.
All right, Commissioner Ford,
Are we saying with no live music, no DJ, no promoters?
Yes.
Is that
so
part
we're
of what this?
with the changes proposed in the supplemental letter.
And just to be clear, they're asking to keep the DJ. What they offered was no. They've said that they are willing to have no live music or jukebox, no promoters, and no karaoke. But they do want a DJ. Just to be clear.
So just Commissioner Fan, just so we get everything on it correct, you're approving with the changes as put forth in the
The
supplemental.
Yes.
Okay, Commissioner Ford,
Yes, I'm going to approve with the changes as put forth as well. I mean, they've been operating, place has been operating clean, essentially, what, for about 5 years, same method of operation. And, you know, this is something that we don't get a lot. We had support from some community board members who dissented with the decision to deny, which was, as previously mentioned, was just about almost a tie. So there's almost as many for it as there were against it. So I'm going to vote to approve.
Chairman Bradley,
I'm going to vote to approve as well for the same reasons, with the limitations that they've already offered in their supplemental material, which is no live music or jukebox, will not retain a promoter, will not permit karaoke, and then they also have adjusted hours. Actually, I don't know the adjusted hours. It's Monday through Wednesday, 4 to 2 a.m., Thursday through Friday, 4 to 4 a.m., Saturday, 12 to 4, and Sunday, 12 to 2.
all right, then the next item, 1318. This is another on-premises liquor license, 500-foot hearing, and it's a transfer of an existing business.
This is another tavern karaoke bar that is currently on a temp. It is a 500-foot case. It's going to have 7 employees, principal to manage recorded music and karaoke. Has individual karaoke rooms. The doors, as licensing pointed out, all have opaque glass and cannot be seen inside the private rooms from the outside. There's 4 karaoke rooms. The max occupancy is 54. We'll use the same method of operation as the previous licensee. The previous licensee was also a karaoke bar with no adverse history. We have no protests. We did not get anything from the community board. A principal of the applicant worked here previously for 8 years, and the ALJ did find public interest.
Right then,
And
Commissioner Fan?
was the prior licensee canceled here?
There was no
No, right.
adverse history.
Just not renewed. Okay. All right, I'm gonna vote to approve.
Commissioner Ford,
Well,
Oh, wait, sorry. Let me ask Adam something. Is there a requirement that the glass be clear?
There's
Well,
not
I
a
think-
legal requirement, but I think it would probably be in the interest of the authority to continue to require, it is, we have set precedent of having clear glass and supervision into the rooms so we can see what's going on, or the licensee can see what's going on in the rooms. So certainly would
Okay.
suggest that having transparent glass is the way to go with this.
Yeah, just for the record, the issue is so that we can be sure that an operator can supervise the entire premises. And there's a concern about the ability to do that if he can't even see what's going on behind dark glass.
Yeah, I'm pretty sure she's gonna put curtain over the clear glass, but it's worth trying. I will require clear glass.
All right then, Commissioner Ford,
Yeah, the glass was my question as well. So if we're going to require that to be clear, I will vote to approve as well.
Chairman Bradley,
I will do the same and require the clear glass.
next item is 1319. This is a $5,000 conditional offer.
I'll accept.
Commissioner Ford,
Accept.
Chairman Bradley.
Accept.
Next, we have 1320 is a $5,000 conditional offer.
I thought this was high. I'm gonna go to 1,000.
Commissioner Ford,
Well, because it
I mean,
is
I
a
think it was high because the patron beat up the investigator, but it's the patron, not the staff.
And did kick the investigator and hit the back of his head, not injured. Sounds like she might have been a little toasty. I'm not going to go that low. I'll go to 3,000.
Chairman Bradley.
3,000.
Next, we have 1321 and 28. It's a $4,000 conditional offer.
I'll go to 3,000.
Commissioner Ford,
Yeah, I'll go to 3,002 as well. It was a while ago.
Chairman Bradley.
I'll go to 3,000 as well.
Next item is 1322. This is a new on-premises liquor license.
It's a
For some
restaurant with
reason-
six employees, no security, principal to manage, recorded music only, will not close for private events, max occupancy 74, 60 seats at 15 tables, 7 seats at the bar, has an outdoor patio for 34 in the back of the building, which appears to be surrounded by other buildings. It is not a 500-foot case. It was not previously licensed. The applicant did have another license at another location canceled in 2019. Basically, it was open for about a year and had some egregious violations and then defaulted on the violations and we canceled it. Based on my reading of it, it looked like he turned what was a restaurant into a nightclub. The applicant was previously denied here for failing to comply with conditions of approval. It does need a restroom waiver.
All right, so with that, Commissioner Fan, are you ready to vote?
Yes, this is not a 500-foot case. I hope and I trust that this is just going to be a regular restaurant. So I'm going to vote to approve recorded music only, bathroom waiver, it's okay, and 2 a.m. across the board.
All right, Commissioner Ford,
The disapproval decision in March of 2019, that was from licensing, not the full board. Is that correct?
Correct.
Yeah, that's correct.
Okay. The application says no topless entertainment, but the sign above the stairs leading to the lower level says peep show. Anyone else notice that? Maybe it's just a sign. I don't know.
They're not open right now. They're not on a temp, so I don't know what was going on there before he took the building.
Okay, all right. Well, anyway, I'm gonna agree with Commissioner Fan and vote to approve.
With the 2 a.m. closing?
Yes.
Chairman Bradley.
I'm going to vote to approve as well, very reluctantly. My view is that if this ends up, I mean, he's basically said he's going to have recorded music only, no clothes for private events, and he clearly lied to us the last time in 2019. If we find out he's lying again, and we end up finding a DJ or live music or whatever the case may be, and it's going to be a nightclub, then it's going to be over very quickly. But I'll vote to approve.
You putting the 2 a.m. closing on as well?
Yes.
All right, the next item, 1323. It's a new grocery store beer and wine products license.
We did receive a withdrawal letter from the representative on this application.
Mr. Trivedi, I guess?
Yes. Yeah. So they are withdrawing this application.
All right, then the next item, 1324. It's a new on-premises liquor license subject to the 500-foot law.
So restaurant with 25 employees, no security, principal to manage part-time, and then hire a manager, recorded music only, no dancing. The restaurant will close occasionally for private events. The max occupancy is 205. There are seats at tables for 113, 16 seats at the bar. They have a front and rear patio. The front has 16 seats and the back 24 seats. There are no protests. He owns the restaurant across the street. The applicant does have multiple sales to minor, failure to conform, and COVID violations in other licenses. So he has 5 other licenses. 2 have pending cases. All 5 have adverse history. Overall, there appears to be 5 underage sales, and currently has a $9,000 fine that has not been paid yet because I believe it's deferred. The hours per the public interest statement are 11 a.m. to 4 a.m. 7 days a week. Outdoor patios will be 11 a.m. to 11 p.m. 7 days a week. The ALJ found no public interest. The ALJ raised several questions that he felt we should get answers to before this license was approved. And the applicant indicated he did not meet with the community board because they did not request it. I did not see anything from the community board. Do we have anything?
I don't see it. Just for the record, this is a single owner who has 5 OPs already. He's got this application and 2 others pending. So he's going to expand from 5 to 8 locations. And before the expansion, the kind of sporadic sale to minors indicate that he might not have a handle on managing the 5 that he already has, which is something the board needs to consider.
Particularly with sale to minor.
Yeah. That's the earmark of a guy who may already be overextended. But the other 2, Adam informs me, have already been conditionally approved. So assuming he meets those conditions, he's going to now have 7. This would be number 8. But I believe this is the only 500-foot hearing that was voted that the ALJ found no public interest.
And isn't he just moving across the street? Is it supposed move across?
He's not moving. He owns the place across the street.
Oh, okay. Oh, sorry.
So
Wait, he is moving. I don't know why. I have a note here that says he's moving from across the street to a bigger location.
Yeah, I had that note too someplace, so I read that someplace.
Check.
And find it.
Yeah, but it's right in the front. Yeah, that's right. In the 500-foot hearing decision, he says that the applicant testified that this location, the one across the street, which will close when the application is approved, since the new location is larger, more desirable with outdoor dining and
And
has
it's been,
favorable lease terms.
and it's been abandoned.
Okay.
It's abandoned, so that's why they're moving to it.
Right.
But we can make, I mean, that's an odd way to remove a license. I don't know why you wouldn't have filed for removal, but,
If you want, you
we can make it conditioned on them closing one. Since he put it out there.
Okay, that's fine with me. I'm gonna vote to approve with the condition that he closes the one across the street. Just as applied for, it's fine with me. Thanks.
He has had some sales to minors, 2011, 2012, 2013. There was one in 2016, one in 2018. So, I mean, none of that's good, but none of them were back to back either. And he's paid significant fines for it either, as well. So I'm going to vote to approve the move as well. No, I guess it's not really a move, right?
It will now.
Yeah.
You vote.
All right, so you're,
Way I
Commissioner
did.
Ford, you're approving it subject to the surrender of the other license.
Yes.
I'm just checking them, see if there's any other principles on the other license.
Yeah, Tom, make sure we put that license number on the record as well as the address.
He is the sole principal. The applicant principal is the sole principal of the place across the street. So it'd be solely up to him to surrender that license. So,
Can you tell us what the name of it is and what the serial number and what the address is so everybody's clear?
yeah, it's New York OP 1286938. The license is issued to 920 Avenue Tavern Corp. at 920 Second Avenue. That's
I'm
what
sorry,
we're talking
Tom.
about.
And did you say that he's the only principal on that one, or do we not really know that?
No, I am looking at our records, and he is listed as the only principal of that licensee.
Okay, great.
Assuming that's the one we're talking about. I'm just looking at the material in the memo. That's the only one on Second Avenue that I can
Second Avenue.
see.
Is it in the 900s?
It's 920, and this is
Okay.
937.
Yeah, that's the one. Okay.
So
That's fine.
clear, then that's the license then, as he is the sole principal that we would require to be surrendered before this license is issued.
Yes.
Commissioner Fan,
Yes.
Commissioner Ford,
Yes.
Cameron, I didn't get your vote yet, so.
I'm going to vote. What were the hours they put on it? 2 a.m.?
We didn't.
Nobody put any hours on anything yet.
Go ahead.
I'm going to vote to approve, conditioned on the other license closing that you already identified. I found it somewhat disconcerting that the attorney tried to minimize the applicant's adverse history. He does have what I would call significant adverse history, some of which is in the distant past, but some of it isn't. And he has a significant number of sales to minors, which, as counsel pointed out, is a clear indication of a lack of supervision. But given that he has already indicated he's going to turn in one license and basically replace it with another, I vote to approve. I am going to, I'd like to limit the hours outside to 11 a.m. to 10 p.m. 7 days a week, and then indoors 11 to 2 7 days a week.
Okay. I'm fine with that.
All right, so 2 a.m. inside, 11 p.m. outside. Commissioner Ford, are you okay with that?
Yes, yep.
All right. Then the next item is 1325. This is a new on-premises wine license.
This is a restaurant with 4 employees, restaurant wine, no security, principal to manage, recorded and live music as well as karaoke. Max occupancy 74. They have seating for 30. The previous license here had extensive adverse history, including a summary and a cancellation. The applicant principal claims to have owned the restaurant, this restaurant, while the prior license was in effect. They did try to explain it and indicated, even though the paperwork shows that she took ownership in January of 2018, she indicates she did not take actual owner or possession until April of 2018, trying to get out of the window when those other violations occurred. The investment listed on the application is less than half of the first month's rent. They tried to explain that by saying that they only indicated the investment in getting the liquor license, not in the location itself, because the location has been open. The CB has no objection, although there are indications that the NYPD is said to have concerns because the restaurant wants to be open 24 hours on Friday, Saturday, and Sunday, with alcohol sales ending at 4 a.m. on Friday and Saturday and 2 a.m. on Sunday. The Monday through Thursday hours will be 8 to 12 a.m.
Yes, and just for the record, the timing of what happened in the prior location, with the prior license, the applicant says she owned since January of 2018. That license was still in effect until at least May 28th, 2018, when the license was suspended, and it was ultimately canceled after that. The explanation for this January date, and by the way, the applicant is not on that license as an owner. Explanation of the applicant is that she was in negotiations with the landlord for a while. That was just when they opened the entity. Did not know what was going on in the location during that period of time, try to distance themselves from it. But that's frankly hard to believe because the location was open during that 4 or 5 month period under another license. It was then suspended, and there was arguably a suspension notice taped to the door. And for some reason, this applicant has maintained ownership of this location, which is a sports grill. At least that's the incorporation name. But since 2018, unlicensed, and has been open. So anyway, for the record.
All right, with that, Commissioner Fan, are you ready to vote? You're muted, Commissioner Fan.
I find the application misleading, confusing. I vote to deny.
Commissioner Ford,
The applicant tries to make some clarification that he had no history with the prior owner. Corporation was formed during the acquisition. That nothing intentional went on. Misleading. The hours are kind of weird. I've never seen anything like that before. Community board has no objection. So I'm going to vote to approve.
Chairman Bradley.
I'm going to vote to deny as well. I agree with Commissioner Fan that this application is completely insufficient and confusing. The owner took ownership on paper in January of 2018, but then argues that they didn't take possession until April of 2018, even though all the indications are that at that time she owned the business. the investment isn't even enough to pay the representative, which we have an idea of what representatives get for filling out these applications, and it's not even indicated on the paperwork what the investment is that is in this establishment, regardless of how she tries to explain it away. And then she says she's having 4 employees, but will be open 24 hours a day on Fridays, Saturdays, and Sundays. I don't see how that's physically possible for 4 employees to run a restaurant of this size for 24 hours straight. So there's whatever is going on here. The problem is we can't tell from the application, and I'm not going to approve based on what was given to us here.
All right, then the next item, 1326. It's a new on-premises liquor license application.
This is a restaurant with 12 employees, 1 security guard. Both principals will co-manage live music and DJs. Does not indicate on the license whether they plan on using, on the application, whether they plan on using a promoter or not, or whether they intend on having private events or not. And those questions are actually pretty clear and specific on the application, so that raises the hairs on the back of my neck. The max occupancy is 74 with seating for 64 plus 10 seats at the bar, which brings them to 74 with no employees. Overall, the applicant has 12 active licenses. The applicants have 12 active licenses. 1 principal has 2 licenses with violations of COVID-19 executive orders. 3 other principals have pending COVID violations. They indicate that the chef will be on the premises all hours of operations. There are no protests. And this is not a 500-foot case. They do not indicate what their hours plan to be.
Yes, so there are 5 separate cases against this ownership group at 4 of their locations. And in some of those cases, 1, 2, 3 of them, they've defaulted on EO charges. So like the earlier one, you not only have executive order violations at multiple locations, but defaults, which again suggests an overextended ownership group already.
All right, then, Commissioner Fan, are you ready to vote? You're muted, Commissioner Fan.
Sorry. A lot of activity over here. I just, given that this is a chain, and this is the new location of an established business, I'm going to vote to approve. Yeah, I'll let the chairman set the hours.
Commissioner Ford,
I'm going to vote to deny based on all the other outstanding charges, current and past. And it says on the application about the food, it says chef will be there 40 hours a week. That's not the entire time that the place is open. So I'm going to vote to deny.
Chairman Bradley,
I'm actually going to vote to deny as well because of the character and fitness of the owners, given the multiple pending disciplinary proceedings. And many licensees have pending disciplinary proceedings, but not so many have this many where they've defaulted on them. And obviously, 1 default is completely understandable given the situation with the U.S. mail, but I believe we have 5 defaults here, or at least 3.
At least 3, and in the other cases, they pleaded not guilty. So it's not just a question of not doing paperwork. They just don't seem to have a handle on everything that's come in against them.
So I'm going to vote to deny.
all right, the next item is 1327. It's a $5,000 conditional offer. Commissioner Fan,
Sorry, I'll accept 5,000.
Commissioner Ford,
I'll accept.
Chairman Bradley.
There are other licenses.
I'll accept. And just so the commissioners know, this is restaurant on Hudson Street that was related to the prior application that we
Yeah.
denied?
Yep. Tom, can I take 2 minutes?
Sure thing. We'll take a brief recess.
Take
for
it
the
10. Just make it 10 minutes, Tom.
All right, we'll be back at approximately 11:15.
Okay.
Deputy Commissioner Roberts, are you still with us?
I am.
Okay. Commissioner Fan, are you back yet, or?
Yep. Sorry, hold on
Okay.
a second.
That's a. You just don't have your video yet, Commissioner Fan. Whenever you're ready, we'll go.
I'm here.
Okay.
Hi, thank you.
All right, then, we are back on the record. The next item is 1329. This is a $5,000 conditional offer.
I'll accept 5,000.
All right, Commissioner Ford,
Sorry, I'm technology challenged. I'll accept.
and Chairman Bradley.
I'll accept.
Next item is 1330. It's a $3,000 conditional offer.
I'll take 3,000.
Commissioner Ford,
3,000 accept.
Chairman Bradley.
I'll accept.
Next item, 1331, is a $1,500 conditional offer.
1,500 accept.
Commissioner Ford
1,500 accept.
and Chairman Bradley.
I'll accept.
The next items, 1332 and 33. This is an offer of $2,000.
2,000 accept.
Commissioner Ford,
2,000 accept.
Chairman Bradley.
I'll accept.
1334 is a default to 4 charges.
1,500.
Commissioner Ford,
I'll do 1,500 as well.
Chairman Bradley.
1,500.
Next item, 1335, a $1,500 conditional offer.
I'll accept 1,500.
Commissioner Ford,
Accept.
Chairman Bradley.
Accept.
1336 is a $10,000 conditional offer. Commissioner Fan, when you're ready.
This grocery store was clearly planned to be a casino with the extensive arrangement that they made to hide machines. I'm at cancel and bond.
Commissioner Ford,
Yeah, these guys were deviously, intentionally misleading in what they were doing here. So I'm at cancel and bond as well.
Chairman Bradley.
Cancel and bond.
Next is 1337. This is a no contest plea. This license has expired.
I'm at 5,000.
Commissioner Ford,
I'm at cancel and bond.
Chairman Bradley.
I'll go 5,000. Only because of their lack of history over 6 years. Otherwise, I would be with Commissioner Ford.
The next item is 1338. This is a default at pleading. And the licensee has another default with respect to agenda number 1339. So on 1338, Commissioner Fan,
1,500 accept. I'll take 1,500, sorry.
Commissioner Ford,
1,500.
Chairman Bradley,
1,500.
and in 1339, the same licensee, another default.
I'm at 2,000.
Commissioner Ford,
2,000.
Chairman Bradley,
2,000.
1340 and 41 is a $10,000 conditional offer, and counsel's office wants charge number 2 in the second proceeding withdrawn.
Withdraw charge 2 and accept 10,000.
Commissioner Ford,
Sorry. Yeah, withdraw council 2 and accept 10,000.
Chairman Bradley,
I'll take 10,000.
1342 is a pleading default. Commissioner Fan, when you're ready.
I'm at 1,000.
Commissioner Ford,
1,000.
Chairman Bradley,
1,500.
1343 is another pleading default.
$1,500.
Commissioner Ford,
1,500.
Chairman Bradley,
1,500.
1344 is another pleading default on 3 charges.
2,000.
Commissioner Ford,
2,000 is what I had as well.
Chairman Bradley,
2,000.
1345, a $1,500 conditional offer.
1,500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley,
Accept.
1346 is a $3,000 conditional offer.
Take 3,000.
Commissioner Ford
3,000 accept.
and Chairman Bradley.
Accept.
1347 is a pleading default to 2 charges.
1,500.
All right, Commissioner Ford,
1,500.
Chairman Bradley.
1,500.
Next item is 1348, a pleading default to 2 charges.
1,500.
Thank you, Commissioner Fan. Commissioner Ford,
1,500.
Chairman Bradley.
1,500.
Next, we have 1349. This is a pleading default to 3 charges. The same licensee has item 1350, which is another pleading default. So with respect to 1349, Commissioner Fan, when you're ready.
I'm at 1,500.
Commissioner Ford,
Since it was just recently licensed, playing pool, patron standing and consuming in a yellow zone at the time, I'm a little higher than that. I'm going to go to 2,000.
Chairman Bradley.
1,500.
All right, next item, same licensee, 1350 default to 3 charges.
$2,000.
Thank you, Commissioner Fan. Commissioner Ford,
2,000.
Chairman Bradley,
3,000.
Wait, what were the numbers again now?
it's 2,000 from Commissioner Fan, 2,000 from Commissioner Ford, 3,000 from Chairman Bradley.
Okay.
1351 is a pleading default to 2 charges. Commissioner Fan, when you're ready.
I'm at 1,500.
Commissioner Ford,
1,500.
Chairman Bradley,
1,500.
next is 1352, a pleading default to 2 charges.
I'm at 1,500.
Commissioner Ford,
1,500.
Chairman Bradley.
1,500.
Next is 1353. This is another pleading default to 9 charges. This license was surrendered in November.
Cancel and bond.
Commissioner Ford,
Cancel and bond.
Chairman Bradley. Chairman Bradley,
I didn't hear the other 2 commissioners vote.
cancel and bond.
Oh, you didn't hear us. I was at cancel and bond. There's something with the transmission going on.
Is it delayed on your end?
I don't know. I was clear when you asked the first time, I was clear at cancel and bond, and then I'm looking at the screen and see that video is breaking up periodically, but go ahead.
The video is breaking up, and we also have a little bit of an echo in here, but I think it's okay.
Nobody else is connected to the meeting from that room, are they? You're only connected on the monitor?
Correct.
All right.
Looks okay
The
now.
next item is 1354. This is a default. However, yesterday, Secretary's office did receive an email from an attorney with the notice of appearance asking for the case to be held over, that they inadvertently failed to respond and they wanted to accept the $1,500. And apparently they've been in touch with the prosecutor. So
Does anyone plan on going? So their letter to you indicated that they got the NOP, but they didn't respond to it?
they're indicating that according to the email from the attorney, that the client inadvertently failed to respond and wants to avoid default judgment by accepting the C&C of $1,500, but is asking that it be held over to the next meeting.
Okay. Creates more work for everybody. All right, go ahead.
So over until 5/26? Or do you just want to proceed?
No, we'll put it over at his request.
Okay. The next items, 1355 and 1356. This is an offer of $7,500 and surrender of their license. The license was summarily suspended back in August. I would note that there's no license to surrender because the license expired in February. So with that, Commissioner Sanders,
if we accept the 7,500, that's not a counter offer, right? If we accept the fine?
no, we'd be accepting the offer and just reducing it to $7,500.
Okay, that's my recommendation.
Commissioner Fan. You're muted, Commissioner Fan.
7,500.
Commissioner Ford,
7,500 accept.
Chairman Bradley.
7,500.
Next item is 1357. It's a $1,500 conditional offer.
1,500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
Next item is 1358, a $3,000 conditional offer.
I thought this was high. I'm gonna go to 1,000.
Commissioner Ford,
I had 1,500.
Chairman Bradley,
1,500.
next is 1359. It's a $6,500 conditional offer. You're muted, Commissioner Fan, I'm sorry.
Apologies. I'm gonna go to 4,000.
Commissioner Ford,
I'll go to 4,000 as well.
Chairman Bradley.
I was going to go to 3,000 due to the fact that it was a EBT violation, and they are.
It'll be 3,500 because it's 18 or under.
No, then they're licensed for 40 years.
Oh, yeah. Fair enough.
So what are you saying, Chairman? You said what, 3,500?
No, I said 3,000 because I kind of discounted the EBT as almost a minor violation, and then they were licensed for 40 years, so it would be 3,500, but because of the 40 years, it goes down another 500.
I'll do the same. I'll go to 3,000.
I'll go to 3,000.
All right. Next one is 1360. This is a pleading default. License expired back in September.
Cancel and bond.
Commissioner Ford,
Cancel and bond.
Chairman Bradley.
Cancel and bond.
Next is 1361. It's a no contest plea, and counsel's office is requesting that charges 1 and 2 be withdrawn. Commissioner Fan, when you're ready.
I'm at withdrawal 1 and 2 and my 5,000.
Commissioner Ford,
I'll do the same. Withdraw 1 and 2, 5,000.
Chairman Bradley.
Also
Hold
do
on.
5. I will also do 5,000.
$1362 is a $7,500 conditional offer. The license was summarily suspended back in September.
I'm gonna accept 7,500.
Commissioner Ford,
7,500 accept.
Chairman Bradley.
Accept.
1363 is a $1,500 conditional offer.
1,500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1364 is a $1,500 conditional offer.
1,500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1365 is a $1,500 conditional offer.
1,500.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1366, a $1,500 conditional offer.
Accept 1,500.
Commissioner Ford,
Accept.
Manager,
Chairman Bradley.
I'll accept.
1367 is a $1,500 conditional offer.
1,500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1368, a $1,500 conditional offer.
1,500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1369 is a $1,500 conditional offer.
Accept 1,500.
Thank you, Commissioner Fan. Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1370 is a $1,500 conditional offer. License was surrendered last month.
I'll accept 15.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
I'll accept.
1371 is a $1,500 conditional offer.
I'll accept 1,500.
Commissioner Ford
1,500 accepted.
and Chairman Bradley.
Accept.
1372 is a $10,000 conditional offer.
Council's office is requesting that you send this back. We need to adjust the charges.
Okay, I'm okay with that. Thank you.
Commissioner Ford, you good with that?
Back to
Chairman
council.
Bradley.
Yes, I'm fine with it.
All right, next item, 1373 is a conditional offer cancellation and bond claim.
Council's office is asking that this one come back as well to adjust the charges.
Commissioner Fan, you good with that?
Yes, please.
Commissioner Ford,
Back to council.
Chairman Bradley.
Yes.
Next item, 1374. This is a package store removal.
A removal of a package store that we licensed in 2019 in Hudson Yards. They're seeking to move it from Hudson Yards, I assume because of what went on in the pandemic, and Hudson Yards has not been open. They are seeking to move it to the village of Southampton. They're trying to move into a building that in June of 2015, the board denied an application by the same individuals for a package store, I believe 20 feet away. The store will be 3,380 square feet, 2,050 of that will be retail. There are 6 stores within 2.52 miles. The closest store is 0.2 miles away. We have 2 petitions, one in support, which doesn't really give addresses, but does have signatures, and then one against, which gives addresses and signatures. There are significant protests. There's protests from 2 stores. There's protests from the PTO president of Southampton Elementary School. There's a protest from the Southampton Associate Board of Directors, which I believe is an association representing homeowners. There are also resident protests. The local assemblyman sent a letter of protest. The village mayor sent a letter of protest, and the Southampton town supervisor sent a letter of protest. All of which basically state that there is no public convenience and advantage to adding another store there, that they're being adequately serviced in the village of Southampton. And the PTO president has a concern about how close the parking, or I believe they share a parking lot with the elementary school, but it's clear that the store is not within 200 feet. The principals have many licenses. They own a chain of supermarkets, and they have very little adverse history. The store will have 3 to 5 employees and a hired manager. And I think that's all I got.
Yeah, I have a few things. There was a letter submitted in support of the application that has a number of points in it that I think have a potential to distort the record that I need to mention for the members. The first thing is that the letter describes how a number of metrics have risen in Southampton, including real estate sales, post office address transfers, an uptick in population, and sales numbers. It even goes so far as to call this the quote, new normal, end quote, in the area. And the letter does that without ever mentioning the elephant in the room, which is that there's a pandemic. And doesn't even attempt to describe its view as to why these shifts that occurred during the pandemic would continue or not continue, which I guess is a matter of potential dispute. And that is relevant because the board, in looking at such metrics, looks at trends to determine whether there's an increased demand for alcoholic beverages that would suggest public convenience and advantage for an additional store, which is going to be there, presumably after the pandemic ends. The other thing is, a second thing is the letter mentions or critiques some of the opposition's letters as being unsigned and that should go to the weight of those letters. I'm not quite sure what's meant by that. If the contention is that the letters are forgeries because they're not signed, I don't know that we have any evidence of that. But it's a pretty sharp question to say that it should go to weight when a competing store doesn't happen to sign its letter.
Well, no, we don't require people to sign them either. We accept them unsigned.
But, it's also a little rich for something like that to be said when the same letter attaches a petition from 2,800 with 2,800 names and contends that they are community members, but there's no column for addresses in the petition. And there's no representation at the top that only people who live in the community should sign it, as there is for the petition that was put in opposition. And we don't even have in the letter a representation as to where these petitions were issued or where they were signed. So with respect to the evidentiary weight of submissions, in fairness, I think that needs to be considered by the board as well. There's also a representation in the letter that the offerings of this proposed store would be unique. That's the word that's used. And then goes on to describe the offerings, presumably of the store as it exists in Hudson Yards. Presumably the suggestion is that these product offerings are not available in the other stores in the area, but no representation is made that any comparison was done to those other stores to see what it is they're actually selling and whether the products that are described in the letter are indeed unique. There's also a mention in the letter about the Moreland Commission from 1964. The suggestion being that competition is all that matters, and that because the Moreland Commission said that competition is what matters, that other factors, presumably that the board looks at in every liquor store case, should not be considered or should be considered less important. We see this reference to the Moreland Commission frequently in these letters, and I responded directly to some of the lawyers who quote the Moreland Commission because I believe that the quoting of it for the premise that there's something untoward about relying on local sales numbers of other stores, that there's something wrong with that, and that's really not what the law says. And I just want to raise that, for the representative in this case and for anybody else who's listening, that they should look closely at the Synacor case, Synacor v. New York State Liquor Authority, 1968, which was on the heels of this Moreland Commission. The Moreland Commission and the statutory changes in the 1960s related only to distance restrictions. They eliminated distance restrictions, which were per se restrictions on where a liquor store could be. Didn't go any further than that. But the Court of Appeals, in considering what the authority's role should be in applying public convenience and advantage, said the following. and I'm quoting, "The terms public convenience and public advantage must have some fixed content if the right to review is not to be meaningless. But the weight to be accorded either interest, and more fundamentally, the factors to be viewed as furthering one or the other of these interests in a given case, are matters delegated to the authority for decision, and unless its determination is arbitrary or capricious, it may not be disturbed by the courts," end quote. So what the Court of Appeals was saying in 1968 was that it is up to the authority to decide what factors are important for public convenience and advantage. And the authority has applied in I think for decades, an analysis of local sales from nearby stores as a means to determine whether or not there's an increased demand for alcoholic beverages in the area as a factor to be considered in this analysis. And that has not been challenged successfully in court, to my knowledge. And indeed, in the last year, we have two decisions from appellate courts in New York State in the matter of Urbanite Wine Merchants case in the First Department, and in the matter of White Plains Fine Wines in the Third Department. In both cases, approving the authority's reliance on that data in connection with a liquor store application. And in the matter of Urbanite, it was actually the reversal of a trial judge's decision to overturn an authority ruling on public convenience and advantage. So I don't think the Moreland Commission stuff makes it, and I do think it's appropriate for the members to consider, in this case and every other liquor store case, the trends in sales revenue of the neighboring stores, and to give the most recent numbers, the 2020 numbers, which have understandably gone up because restaurants have been closed, an assessment with that fact in mind. And then I'll stop talking.
Well, and I think there's no question that there people during the pandemic did move out there, so the population, whether it's temporary or not, did go up, at least for the pandemic.
That's true.
All right, with that, Commissioner Fan, are you ready to vote?
There are a number of issues that are of concern here. First, I guess I'm not sure about a removal that's 93 miles away. I think that's setting up for precedent, and clearly this applicant had applied before and was denied, and this removal. If the building was purchased in 2018 and the wine store was issued in 2019, timeline-wise, it kind of falls into the removal policy that Gary had been talking about over the last few meetings. That's one issue. Second issue is I have a question, because in the application they talk about deliveries. They don't need a physical store out there to do deliveries, right? Right now it's legal for them to do deliveries out east because they have the store in the Hudson Yards, right?
Yeah, they can deliver anywhere they want in New York State.
Okay.
That doesn't mean that they do.
Yeah,
But-
no, I understand.
and-
I'm just saying that
Okay.
yeah.
But it doesn't mean that they can transact liquor store business in a grocery store that happens
no,
to
they
be in
can't.
Southampton.
No, they can
They
do it
can't-
on the internet.
They can't take orders in there and pretend they're a liquor store if they don't have a license to sell. If they don't have a package store license in Southampton.
Okay. I know there's a lot of political protests, and I feel like this is sort of a fight between the registered voters and the broader population here. And the issues with the school, I don't necessarily feel like it's applicable just because it's more than 200 foot away. So I just have a lot of experience in this area, and I am thinking from the consumer standpoint, when I think about public convenience, I feel like it is my job is to think about the public convenience for the consumer. And this board has always considered proximity to a grocery store as public convenience. And I'm thinking about the ability to deliver to the rest of the East End area as being a real benefit to a lot of people that don't want to drive or don't want to go to a store right now during this time, since home deliveries has become a norm. I'm looking at the numbers that was submitted by the closest store, even though they make the argument that the sales were only in the summer, but I'm looking at it and the sales were high all throughout the fall. So I don't really buy that argument. I know it's a long way of saying, I think I find public convenience. I know there's a lot of protests and there's a lot of negativity on this one, but I really do just personally, I just believe that there is public convenience. So I'm going to vote to approve.
All right, Commissioner Ford.
And as you should, Commissioner, you should vote the way you see fit. That is your right and the reason why we're all here. I have to correct a couple things in the letter from the representative to support this application, that a couple of letters were not signed when in fact they were. The Southampton School PTA was signed by Delaney Oser, and the Southampton Association was signed by Bruce Bachman. So those two documents were in fact signed. Based on the, I'm looking at the numbers too, and it looks like everybody, all the stores are doing pretty steady until they got the COVID 2020 bump. And the last further store, like substantially from like 6,300,000 to over 9 million. All the others went up appreciably too, one by 3 million. So, but I do think that's going to be short-lived. I do think that is a bump. And based on all the opposition from the assemblyman and the mayor, former congressman, Southampton town supervisor, Southampton mayor, Southampton village trustee, and others, I'm going to vote to deny.
All right then, Chairman Bradley.
I just want to check one thing. Commissioner Ford pointed out there is significant opposition to this, not just from elected officials, but from residents, from an association that represents apparently over 300 homeowners, indicating that this is not in the public interest. There are 5 stores within 2.5 miles. The closest store is 2 miles away. 0.2, I'm sorry, away. The second closest is 0.4 miles away. Presumably, all 6 of those stores within 2.5 miles would have the ability to deliver to anywhere on the east end of Long Island. And what I was also checking was that this store is going to be 3,380 square feet, 2,050 of which will be retail. That makes it bigger than the 2 closest stores. It makes it double the size of the 2 closest stores, which are also, oh, I'm sorry, not double, but it makes it bigger than the 2 closest stores, which are also located in the village of Southampton. And also notable to me is the fact that they applied for a store 20 feet away in 2015, which was right before I got here, and it was denied. There's no question that there's more activity in Southampton right now because of the pandemic, But I would expect that to go back to the normal within the coming months once the pandemic clears up. So I'm going to agree with all the elected officials that have chimed in here and say that I don't see any public convenience and advantage whatsoever to adding another store in a village this size. And one thing we have done pretty regularly is take the local elected officials' idea that they know their communities better than we do. And in this case, not only do we have the mayor of the village, but we also have the town supervisor, and you don't always get two elected officials to agree on anything. So that being said, I just don't see any public convenience and advantage to adding another one in Southampton at this time.
All right, then, the next item, 1375. This is a new package store license.
This is a store, principal to manage with 2 employees. The principals have no liquor store experience, but they do own, one of the principals owns a grocery store license with little adverse history. The store is going to be 1,495 square feet. 1,380 will be retail. The closest store is 6.3 miles away, and there are 4 stores within 8.3 miles. It will not be bulletproof. There is no protest, and the principals are husband and wife, so it appears it's going to be a family-owned store.
All right, with that, Commissioner Fan, are you ready to vote?
Yeah, we don't get responses from 3 of the 4 closest store. The closest one is 6 miles away. I'm gonna vote to approve.
Commissioner Ford?
I vote to approve as well. No protest
Chair-
and public convenience.
Chairman Bradley?
Yeah, I think the distance to the closest store is public convenience and advantage in and of itself.
All right, then, next item is 1376. This is a new package store license.
Store with 2 to 3 employees, principal to manage, and will employ a manager. It's 1,107 square feet. 653 of that will be retail. The closest store is 0.8 miles away. There are 4 stores within 1.5 miles. There is 1 protest, and the applicant and the store manager both say they will manage but continue their current jobs as postal carriers, which raises questions because that obviously is a full-time day job. This location was previously licensed as a package store twice. The last one closed in June 30th of 2016. There's no adverse history at the location.
But Adam,
Commissioner-
the store has been replaced quite a few times over at this point between 2016 and now, right?
Correct.
This is going to be bulletproof too. I failed to point that out. It is going to be bulletproof. 3 of the 4 closest are bulletproof. The 4th closest is not bulletproof.
They're all, oh, yes, you're right, you're right. Yeah.
Yeah, so given that the principals have no experience and plan to do 2 jobs at the, which is, it's unclear how he would do that, and the numbers are flat at best if you take out the COVID numbers. I'm gonna vote to deny.
Commissioner Ford?
Yeah, I'm concerned about that. The principals don't have any prior experience. They're both working full-time jobs. They both have full-time gigs working for the post office. None of the other stores seem to be tearing it up, holding their own maybe. And I just don't see that this area needs another bulletproof store, so I'm voting to deny.
Chairman Bradley?
I'm going to vote to deny as well. I don't see adding a bulletproof store in this area being any public convenience and advantage. That or adding to the public convenience and advantage. There's 3 bulletproof stores here already. There's 4 stores in 1.5 miles. And I am concerned the both individuals are going to keep their full-time jobs, but both manage the location. But mostly it's because I don't see public convenience and advantage.
All right, then, the next item, 1377. This is a on-premises liquor license application to transfer, and it's a 500-foot hearing matter.
Licensee is, or applicant is on a temporary license or a temporary permit. It's a restaurant with 7 employees, no security, principal to manage, recorded music only, no dancing, max occupancy of 74, table seating for 28. They have a customer bar with 9 seats. They will not have private events. The community board recommends denial. There are residential apartments upstairs, but the previous license here had little to no adverse history. They do need a bathroom waiver. The ALJ found public interest, but did not see the community board letter. The proposed hours are 11 a.m. to 12 a.m. Friday and Sunday, 11 a.m. to 2 a.m. The community board letter is somewhat confusing to me because it's written in a way that indicates that they think we're adding a restaurant instead of just transferring one that already exists, and that they believe that the 500-foot rule is that granting this license would be an exception.
I'm sorry, say that again?
That
The-
confused
the-
me.
the-
That confused
the-
me too, Chairman.
The community board's letter is written as if this is a new license and that the 500-foot, that we'd be granting an exception to the 500-foot law, but they don't seem to acknowledge that this establishment already exists, and it's a transfer. They're speaking as if we're adding another license to this neighborhood, and that is not what's occurring. The applicant has the same method of operation as the previous license. But I do have a question regarding the investment. I don't think they have 100% of their investment in there, but that's all I have.
Yeah, I would also note that the community board's objection, unlike most community board objections that we've seen, doesn't explain why under any of the factors that we consider there should be no license in this location. Just says we don't like a lot of licenses. So it's a little threadbare.
The,
All right, then, Commissioner.
the rent amount too, on question 18 on the memo, says amount 4,800 to 6,800 at lease end. Am I to assume that's per year? So it escalates.
No, that's a month. That's per month, and it's going to escalate. It's going to escalate over the course of the lease.
Okay.
But it does indicate that they invested $5,000, which I don't even know if that pays for the cost of getting the license.
Well, it was previously licensed, right? So maybe there was a lot there that they could already use. Is that possible? I don't know.
Yes, that's possible.
Certainly need to serve the liquor they're asking us to license them to sell. You need to own it and sell it.
All right, then, Commissioner Fan, are you ready to vote?
Yes, I'm gonna vote to approve, Monday to Thursday until midnight, Friday, Saturday, Sunday until 2 a.m. Recorded music only, no dancing. No promoters.
All right, then, Commissioner Ford.
The applicant has no adverse history. Premises does. but this is going to be my, oh, what the heck today, and I'm going to vote to approve.
Okay.
Are you approving with the same hour limitations as Commissioner Fan noted?
Everything that Commissioner Fan said, yes.
Chairman Bradley?
I'm going to vote to approve as well. Just so it's clear that the previous license here had very little adverse history, which is mainly why I'm approving it. I will do it the same hours that Commissioner Fan conditioned it on.
And just to clarify, Commissioner Fan, that was 2 a.m.
Sorry, it's Monday through Thursday, 12 o'clock, and Friday, Saturday, Sunday, 2 a.m. It's actually the hours that they have in the application.
listed. Okay, I just want to make sure.
Yeah.
Thank you.
Mm-hmm.
At the next item, 1378, it's a new package store license.
Yeah. This is a store with no employees, principal to manage. The principal has no experience, but does have an on-premises license in the area. It's going to be 480 square feet, 335 of that will be retail. The applicant owns the building. The closest store is 5.2 miles away. There are 4 stores within 5.3 miles. All the stores, including the applicant, are not bulletproof.
All right then, Commissioner Fan, you ready to vote?
I find it an incredible coincidence that the 4 closest stores are all 5.2 or 3 miles away. It's very interesting to me.
I noticed that as well.
Sorry. Gotta find some fun when you do this stuff, so I'm gonna vote to approve.
Commissioner Ford?
And one of the stores that didn't respond, Rafters Tavern, it's a tavern that has a package store license. Can that be?
I'd have to look. I mean, they may be at the same premises. They wouldn't be able to have both license types at the same premises.
Okay.
They would have to be distinct and separate from one another.
Would you, not right now, Adam, but would you make a note of that and get back to me? Because I had that question about, I should have asked you about that before.
Sure.
But I'm going to vote to approve as well. I mean, there's nothing around here, and it's definitely public convenience. An advantage for this little, I'm not even sure it qualifies as a hamlet, so, but I would vote to approve.
All right, Chairman Bradley?
I'm going to vote to approve as well, just based on the distances, which was pointed out. I think there's convenience and advantage, given that the closest store is 5.2 miles away.
All right, then we're a little over halfway through at least the number of items. Do you want to take a break at this point, or you want to keep moving forward?
I can keep going, but
I'd like to take just 5 minutes. Could we do that?
yeah.
Just 5 minutes. That's
Well, it's 12:08 now, so why don't we make it, we'll come back at
12:15.
like 12:15,
perfect.
right? Okay, thank you. All right, then Adam, are you with us?
I'm still here.
Okay. Commissioner Ford, are you ready to get going?
Yes.
Commissioner Fan, are you ready to get going?
Yeah.
All right, then. Chairman, are you ready?
Yes.
Okay, then, next item. 1379, it's a new package store license.
This is a store with 2 employees and a hired manager. One principal managed a liquor store previously. Both principals say they will actively manage this store. It's in Suffolk County, 528 square feet, 264 will be retail. It is not bulletproof. There are 8 package store protesters. Closest store is 1.2 miles away. There are 4 within 2.3 miles. The opposition says there are 10 stores within 4 miles. They also indicate that there are 2 stores already in St. James, New York, where this store will be located.
Yeah, I will note that the representative in support of the application notes that the review criteria have changed from the number of stores within 1 mile to the number of stores within 2 miles.
Yeah,
Which is,
at my instruction, secretary pointed out to him that he's completely misstated the law, and that the review by this board as well as the law did not change.
Yeah.
It's public convenience and advantage.
yeah, I don't know where he got that.
But we did send an email
And
correcting.
that was really the only point made in favor of the application in that letter.
All right, then, with that, Commissioner Fan, are you ready to vote?
Yes, I would bring up an additional concern, which is that there are pictures of lots of bottles of alcohol, which I'm not really sure why this was in the application. But I'm going to vote to deny.
Commissioner Ford,
I had the same thought about that. I didn't know where that picture came from. Kind of doesn't make sense. But the stores that did report had steady sales, more or less, but with the COVID bump. But I don't think that's indicative of a continued rise in business. As I said on another couple of cases, I would expect sales to subsidize to normal pretty soon. But that being said, looking at the population density and the location of this proposed store, and given its small size, it's only 264 square feet retail. I think it does meet public convenience and advantage, so I would approve.
Chairman Bradley,
As I indicated, there's already 2 stores in St. James. It's a small municipality. There's no evidence that the population is increasing, and if it is, it can be attributed, I'm sure, to the pandemic. There is no evidence presented by the applicant regarding products or services that are not already being offered by the other nearby stores. There are 4 stores within 2.3 miles in a driving community, so I just don't see the public convenience and advantage of adding another one at this time.
yeah, disapproval then?
Yes.
Yes.
Yes. All right, then, 1380 is a $1,500 conditional offer. And the next item, 1381, involves the same licensee. This one is a $1,500 conditional offer.
I'll accept 1,500.
Commissioner Ford,
I'll accept 1,500.
Chairman Bradley.
1,500.
All right, 1381 is a default regarding that same licensee.
1,500.
Commissioner Ford,
I'll do 1,500.
Chairman Bradley.
2,500.
Next item, 1382 is a $3,500 conditional offer.
I'll accept.
Commissioner Ford,
I'll accept.
Chairman Bradley.
I'll accept.
1383 is a pleading default to 2 charges.
What's a TL license? Does anyone know? This is obviously an older license.
This is
Tavern
this
liquor.
is the tavern. This is before the agency consolidated to referring to all of them as OPs. We would have RLs, the restaurant liquors, tavern liquors. EL would be the entertainment liquor. They were all broken down by the type of venue.
Okay.
Commissioner Fan,
I'm at 2,000.
Commissioner Ford,
I'll do 2,000 as well.
Chairman Bradley,
1,000.
1384. It's a pleading default to 3 charges.
I'm at 1,500.
Commissioner Ford,
What case are we on?
1384.
1,500.
Chairman Bradley, Chairman Bradley,
1,500.
next item 1385. It's a pleading default to 2 charges.
I'm at 10,000.
Commissioner Ford,
I'm at 7,000.
Chairman
10,000.
Bradley, 10,000.
I'll make it unanimous. I'll go 10,000.
Okay. Next is 1386. So no contest, conditional no contest plea, $20,000 civil penalty. The license has been summarily suspended since February 14th. Commissioner Fan, whenever you're ready.
Another AX license with a new AX license with gambling and untaxed cigarettes. Starting out on the wrong foot. I'm at cancel and bond.
Commissioner Ford,
I'm at cancel and bond as well. For the same reasons as Commissioner Fan noted.
Cancel and bond.
all right then. Next item, 1387. It's a $1,500 conditional offer.
1,500 accept.
Thank you, Commissioner Fan. Commissioner Ford,
Accept 1,500.
Chairman Bradley.
1,500.
1388 is a $1,500 conditional offer.
I'm gonna go 750.
All right, Commissioner Ford,
Yeah, license, what, like 35 years ago, something like that? I'll go to 750 as well.
Chairman Bradley.
1,500.
1389 is a pleading default to 3 charges. Commissioner Fan,
I'm at 1,500.
Commissioner Ford,
1,500.
Chairman Bradley.
1,500.
Next items, 1390 and 91. This is a $6,500 conditional offer to 2 different pleadings.
There was clear notice between these 2 sale to minors, so I am gonna go to 9,000.
Commissioner Ford,
That's exactly what I had, 9,000.
Chairman Bradley.
$9,000.
Next item, 1392. It's an offer of cancellation and bond claim.
I'll accept, cancel, and bond.
Commissioner Ford,
Cancel and bond.
Chairman Bradley.
Isn't the offer canceling $1,000?
Yes, it's not cancel and bond.
Right.
Sorry, yeah,
Yes.
cancel 1,000.
Yeah, my mistake.
I'll-
Cancel and $1,000 civil penalty.
I'll accept that.
So what are we doing? Are we accepting the offer?
Yes, cancel and the civil, $1,000 civil penalty. That was my error. 1393 is a $10,000 conditional offer.
I'll accept 10,000.
Commissioner Ford,
10,000 accept.
Chairman Bradley.
10,000.
Next item, 1394 is a $1,500 conditional offer.
1,500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1395 is a $10,000 conditional offer.
Yeah, for the record, this is the second and third offense for the suspension of cigarette charges. There was one in the adverse history, and the first two were relatively small amounts of cigarettes, less than a carton, 0.3 and 0.2.
All right, Commissioner Fan,
I'll accept.
Commissioner Ford,
I accept.
Chairman Bradley.
I was going to go to 15,000, but I'll accept.
1396 is a pleading default for 2 charges.
I'm at 2,000.
Thank you, Commissioner Fan. Commissioner Ford,
2,000.
Chairman Bradley.
1,000.
Chairman Bradley.
2,000.
Got it. 1397. This is a default at hearing. This license was surrendered back in February.
Cancel and bond.
Commissioner Ford,
This is 1397.
yes, sir.
Yeah, cancel and bond.
Chairman Bradley.
Cancel and bond.
1398 is a $3,500 conditional offer.
Yeah, we're asking that you send this back to counsel's office so that we can adjust the charges.
Sure.
All right then, Commissioner Ford, you good with that?
Yes, back to council.
Commissioner Fan?
Yes.
Chairman Bradley?
Yes.
1399 is a no contest plea.
I'm at 7,500.
Commissioner Ford,
Turn it back on.
7,500.
What now? Are we on 1399?
I'm sorry,
1399.
750. Sorry, 750. Thanks for catching
Okay, you
me.
scared me
Sorry.
there.
Sorry.
I'll
Sorry.
just take I'll take a 0 off at the end there. Okay. Commissioner Ford,
750.
Chairman Bradley,
I'm at. I'll take 750 as well.
1400 is a $25,000 conditional offer. This license was summarily suspended back in January.
Same thing. AX license, gambling machines, drug activities. I'm at cancel and bond.
Commissioner Ford,
I feel the same way, Commissioner Fan, but the other ones were like recently licensed, like within the past
Yeah.
year. This one's been
I
here
see that.
since 2016, and they've had only, I hate to say only one sale to minor because one is too many, but I'm going to accept. I will vote to accept.
Chairman Bradley,
Yeah, I'm gonna cancel and bond as well. 4 gambling devices, prescription drug on premise. This was a mini casino.
all right, the next item, 1401. This is a $2,000 conditional offer.
Accept.
Commissioner Ford,
I'll accept.
Chairman Bradley.
Accept.
1402, this is a $7,500 conditional offer.
I'm gonna counter at 15,000.
Commissioner Ford,
I'll agree with Commissioner Fan. 15,000.
Chairman Bradley.
15,000.
1403 is a $1,500 conditional no contest plea.
I'll take 15.
Commissioner Ford,
This offer was made April 15th after they surrendered the license in February. So is this in lieu of cancel and bond, or is this just to get the license back? I'm not sure if I understand.
well, they won't get the license back. All right, if they don't pay, then ultimately this is going to get canceled.
Okay. So what did you say, Commissioner Fan? You accept?
Yeah.
I'll accept.
Chairman Bradley,
I'll accept.
Sorry, I dropped my entire stack. Hold on a second.
1404 is a $1,750 offer. Oh wait, we lost.
We lost the commissioner.
Oh, there we go. We got her back.
Sorry, I dropped my entire stack.
1404.
1750, I accept.
Chairman Bradley, Commissioner Ford,
Due to their longevity, I would do 1,000.
That's fair.
Chairman Bradley,
I'll do 1,000 too.
Your 1,000, Commissioner Fan?
Sure.
Let's make it unanimous.
1405 is a $6,000 conditional offer.
6,000 accept.
Commissioner Ford,
6,000 accept.
Chairman Bradley.
Accept.
1406 and 07 is an offer of cancellation for the record. This license, excuse me, was already canceled in another matter.
Cancel for the record.
Commissioner Ford,
Cancel for the record.
Chairman Bradley.
Cancel for the record.
1408 is a $1,500 conditional offer.
1,500 accept.
Commissioner Ford
1,500 accept.
and Chairman Bradley.
Accept.
1409 is a $6,500 conditional offer.
I'll accept 6,500.
Commissioner Ford
6,500 accept.
and Chairman Bradley.
Accept.
1410 is a $6,000 conditional offer.
6,000 accept.
Commissioner Ford
6,000 accept.
and Chairman Bradley.
Accept.
1411 is a $1,500 conditional offer.
I'll accept 1,500.
Thank you, Commissioner Fan. Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1412 is the reconsideration of a package store removal application.
Yeah, for the record, this is an application the board denied, in large part based on the size of the new space under the public convenience and advantage standard. I note that the representative in the letter in support of reconsideration suggested that there's some change in the level of scrutiny based on square footage. That is not correct. The ABC law applies public convenience and advantage to all new licenses and to all transfers and removals. So it's not a change in standard, but they purport to have addressed the issue that concerned the board when it ruled the first time by reducing the square footage from 6,000 to 1,500 square feet.
All right, with that, Commissioner Fan on the request for reconsideration.
I'll vote to reconsider.
Commissioner Ford,
I vote to reconsider.
Chairman Bradley, Chairman Bradley,
So go ahead.
I will, sorry, the microphone was on mute. I'll vote to reconsider.
All right, then, moving on to the application itself. Commissioner Fan,
I'll vote to approve.
Commissioner Ford,
I vote to approve.
Chairman Bradley,
I'm going to vote to approve as well, conditioned on it being 1,500 square feet total area with 1,000 square foot of retail.
Commissioners Fan and Ford, are you agreeable to those conditions?
Sure.
Commissioner Ford?
Yes.
Next item, 1413. It's a request for reconsideration of a disapproval of a new on-premises liquor license application.
Yes.
Oh, go ahead.
I was going to do this.
Go ahead.
For the record, the applicant is a Mr. Whitfield, who was a convicted felon who obtained a recent certificate that would allow him to operate a location. This application was rejected by the board for the same reason that the board rejected the prior applicant's application for this premises. That prior applicant was his mother. In both circumstances, the issues were that the mother had employed Mr. Whitfield illegally as a manager because it was before he had received that certificate and he was a felon, a convicted felon. And under his management, the premises was a danger. There was a shooting there and some other issues. So the board rejected on character and fitness grounds. The board also considered whether or not the clean record or lack of any issues during 2020 should be something that should be considered in his favor, and I guess stated either on the record or in the decision that they didn't know whether it was even open. So he now sends in an unsworn letter seeking reconsideration in which he makes a variety of representations. The first one is that he was open during COVID. In support of that, he puts in an income statement, which is just a word process document with no explanation as to how it was created or where those numbers come from. So I'm not sure. The board can decide what way to get to that. But then he also provides, he claims that there was misinformation considered by the board about his role at the premises during his mother's temporary license. What's interesting is, unlike most circumstances, in that case, his mother actually challenged the denial of the application, and there was a disapproval hearing that took place where the law enforcement officers whose reports had been, the cause for the denial actually testified under oath. It was also striking that at that hearing that the mother asked for, in which she was accused of using her son as a manager and of her son, the manager's involvement in not cooperating with law enforcement. Neither the mother nor the son testified at that hearing, which is a little odd. In any event, He claims that he was not the man. He currently claims in his reconsideration that he was not the manager at his mother's restaurant. He, quote, helped my mother occasionally at her establishment by cooking in the kitchen. He also says that the 5 police calls that were mentioned at the hearing, I assume he's referring to the hearing involving the denial of the application, the disapproval hearing. He says that 3 of those were for the restaurant under the owner previous to my mother. There was an owner previous to his mother. Well, I look back at the hearing records, and the hearing records seem to suggest that Mr. Whitfield, while a felon, was actually the owner of the location prior to his mother, and then represented himself to be the manager to law enforcement while it was operated by his mother. There's a call that was made to the law enforcement in June of 2018 in which Lisa Samek, who was the licensee prior to his mother, says that she is the co-store owner, and she stated that she is having troubles with her business partner, Jadell Whitfield, who was off the scene. CO stated she wants to get him out of the business and own the bar on her own because she doesn't like the way he runs things, and him and his friends yell at her in front of customers. And the police advised that it was a civil issue, but to call back if the arguments or fights escalate. So this is a contemporaneous document from a third party in 2018 that identifies Whitfield, then a convicted felon who could not own a license or hold a license, as the co-owner of the location. So there are at least 3 or 4 times the police visited this location during that period and during his mother's ownership, where Mr. Whitfield, who now claims to be an occasional cook in the kitchen, was the person there when they arrived and represented himself to be the manager. So his current claims are really hard to credit. These are all contemporaneous records. Mr. Whitfield only started denying he was the manager after his mother's license was denied, because in part he was acting as the manager. The particular incident in question that caused, I think, the board the most concern in both occasions was the shooting that took place, at which Mr. Whitfield represented to law enforcement that he was the manager. He now claims that one of the other people in the bar was the manager, not him. But the testimony of that person at the hearing was that she was a bartender and that Jadell Whitfield was the only one with the key to the lock on the door when the police officers were trying to come in. I guess I've said enough, but there's serious questions about the veracity of what Mr. Whitfield is saying now about his prior involvement with these 2 licenses that the board should consider in context with the reconsideration request.
All right, then, on the request for reconsideration, Commissioner Fan, are you ready to vote?
Yes, I'm going to
Yep.
vote to reconsider.
Commissioner Ford? You're muted, Commissioner Ford.
Sorry, Commissioner Fan, you said you voted to reconsider?
Yes.
I'm going to vote no.
Chairman Bradley?
Yeah, I don't see any reason to reconsider. And beyond what counsel said, I just don't see that there's anything new here. He obviously disputes our conclusions. He does give his charitable contributions that he made during the pandemic that I will take at face value, but that doesn't change the facts that I ruled upon previously. So I'm going to vote no reconsideration.
All right, then, the next item is 1414. This is a reconsideration of a disapproval by the full board of a new on-premises liquor license.
This is one of the reasons we denied, or at least one of the issues was that there was not a certificate of disposition supplied by the applicant regarding an arrest that he made. That really was not one of my major issues, but it may have been yours. The ALJ at the time said no public interest. The reconsideration does not address the failure to answer specific questions on the public interest questionnaire, which was one of the reasons that the ALJ said no public interest. And I don't see anything else inside the reconsideration request that is new information that we didn't have, even though the ALJ made a point of the principal's adverse history at their other locations. That was not even dealt with in the reconsideration.
All right, then, on the request for reconsideration, Commissioner Fan,
I vote no.
Commissioner Ford,
I agree. The questions weren't answered. I mean, it's like, maybe he didn't read what the ALJ had said. So those issues still weren't addressed. So I'm going to vote no on reconsideration as well, because there's nothing new here, except the COD.
sorry, Chairman Bradley.
Yeah, I mean, I guess the certificate of disposition was not really an issue I was hung up on. It was more the adverse history and the failure to address some of the specific questions regarding what was going to go on in this license in the basement of a hotel. So I don't see anything new that was presented here that would get me to change my mind.
All right, then the next item, 1450, this is a request for a declaratory ruling.
Yeah, this is a request by the operator at Barclays Center in Brooklyn to have the board say that it would be proper to add a new bar that would have a designated area only accessible to American Express credit card holders. The licensee had previously filed an alteration application to accomplish this. The application was disapproved. And then I believe a reconsideration was disapproved. And the concern was at the time that having an ad bar that was only open and accessible to American Express credit card holders, which the licensee was going to add to create this frictionless point of sale for these select group of the public, so that they could get in and out and I guess swipe a card or show a card that would allow them to pick up drinks and food quickly and get back to their seats in the arena. It was denied because the law does require licenses, on-premise restaurants or taverns to be, quote, open to the public, end quote, based on longstanding case law interpreting ABCL Section 2. This is an OP license, not a club license, and therefore it needs to be open to the public. And this one would only be open to American Express cardholders and members. The requester of the declaratory ruling claims to have fixed this problem by making American Express gift cards available to those who are American Express credit card holders for a $2.95 fee. So with a American Express gift card, you could enter this place, and that therefore makes it open to the public. Note that the lowest denomination in amount for this gift card is $50. The requester says that this solves the problem because now everybody can get in, and Playboy Club of New York v. Hostetter, a case that was decided in the 1960s, supports their position. The Playboy case did stand for the proposition that you could have an entry fee as a requirement for people to get in and use the premises, and that does not run afoul of the requirement that the place be open to the public if it's an entry fee. I look closely at this, and the Playboy Club case does not address a circumstance where there's different treatment for different sectors of the population, which is what the case is here. Not everybody is paying the same thing to get in. Some have an American Express card and don't have to pay $2.95 to get in, or have to have a $50 minimum buy, which is what you have to have if you are getting the gift card. If you're an American Express cardholder, you don't have to do that. There is another case in the law that to me seems more on point. It's called 330 Restaurant Corp. v. State Liquor Authority, 26 New York 2nd, 375, 1970. So this was decided after the Playboy Club case. And in that case, the licensee's method of operation involved giving exclusive hours and preferences to certain members that were enrolled in a membership club. And those hours and availability were not available to others. So there was a distinction between the privileges that one group could have versus another. And the court held that that was a violation of the law. It was a violation of the premise that a location has to be open to the public. I think I have a pithy quote from the case. The court says that the licensee's method of operation involved giving exclusive hours and preferences to members enrolled in its membership club over non-members. It was designed to discourage the general public from seeking admission, and therefore was not really open to the general public as required by the ABCI. So that's the question for the board, whether this proposal meets the legal requirement of being open to the public when patrons who do not hold American Express cards are required to buy in for $50 and pay $2.95 for that privilege, and American Express cardholders are not.
Gary, can you just comment on how this is different from, like, for example, the Delta Club at Madison Square Garden or High Roller Room at a casino, where it's certainly exclusive?
Delta Club comes. I think the Delta Club comes with your ticket.
Yeah, the tickets are available to everybody equally. If you happen to purchase that level of ticket, then you get the privileges associated with that level of ticket. But it doesn't distinguish between. I mean, it doesn't prevent people. No one is excluded from having the same rights to get the same ticket.
And it's not making you buy a product that you may not want, which is here. You know, and the one thing I did when analyzing this, I went and looked, because what if you don't want to spend $50 in this place and you buy the $50 gift card because you figure the $2.95 is not that big a deal. But you have a $50 American Express gift card now, and I spent $10 in the place on beer, or $20 or whatever it may be. Now I have a $30 American Express gift card. I looked up on the internet the number of complaints regarding American Express gift cards as a product. It's remarkable. So basically they're asking you to buy a product that you don't want. There's all kinds of that you may not want. There's all kinds of complaints regarding the balances disappearing from the gift cards, even though you're not spending them. And having read this, if the standard that we're going to use is, would this discourage the general public to enter the establishment? I can tell you, based on what I read, that I would not be buying an American Express gift card just to get in here because of the problems I saw. And it's a product. I mean, the American Express gift card to me is a product, and obviously the Amex credit card requires an application and you have to be approved. And that's based on your credit history, and there's obviously a big percentage of the population that would never be able to get one.
And I also think it's relevant, based on this case law, what the intention here is. And what the court said in that 330 Restaurant Corp case was that if the intention was to discourage a portion of the general public from seeking admission, then it didn't comply with the open to the public rule.
Well, I mean, their hope, however, is more the opposite, right? They want everybody to have an American Express card. Like, it's not to discourage, it's also to encourage people to put themselves in that
Correct.
bucket,
Well, yes and no. They also want to limit the number of people who can have access, because then it's more of a benefit to be in there, right? Because you can get through there quickly. So everybody can't line up there like they do with the other bars in the arena.
I mean, their
How
argument,
big
which
is
they
this space?
their argument that they raise is that if they can't get in or they don't want to buy our product, they can just go somewhere else. But the alternative to that is if there's a street of bars and one of the bars says you have to have this credit card to get in, and if you can't, you go somewhere else, we would never let that place open. Under the law, not having any personal view on it, the law requires open to the public. That's not open to the public. The space, I don't know how big it is.
But there are restaurants that only take Amex.
Yeah, but they also take cash.
Right.
That's the problem here, is that if this place would
No,
take
I
cash, I'd have
appreciate
no
what
issue.
you're saying. I'm not arguing. I just feel like frictionless, consumer experience is kind of where the world is going. And so, but in this case, I'm not sure why they chose to just do it with this one company, because they should create frictionless for every credit card out there, right?
You hit the nail on the head. The reason they did it with this company is it's a marketing thing for
Right.
Amex.
It's sponsorship, and the intention is not to serve the public, it's to do other things. And I do think, I don't know this for sure, but the fact that the American Express cardholders are a select group of people who can, have an American Express card. I don't even have one.
You couldn't get one?
I don't remember. Well, the last time I applied, I couldn't. That was a long time ago. So I don't know if they'd reconsider. But there's, the idea
Not
here
after
is
this.
maybe not. The fair point. Should I stop talking? No. Look, it's our job, obviously, to try to be consistent with the law, and I do think this 330 Restaurant Corp case is more on target than the Playboy case, which if everybody who wanted frictionless had to pay $1.95 and have a $50 minimum buy, then it would be okay under Playboy Club, but it's not. That's not the setup here.
All right.
So with that, Commissioner Fan, are you ready to vote on the request for the ruling?
Yes, I'm going to vote that the method of operation, or the way they plan to do this frictionless business is contrary to the existing law.
All right, Commissioner Ford.
What they're asking us to do is not a clarification. They're asking us for an exception to the rule. And I don't think that's allowable, and I'm going to vote to deny.
Chairman Bradley.
I'm going to vote to deny. I think I've said enough.
And just for the record, Commissioner Ford and Chairman Bradley, your denials are consistent with Commissioner Fan indicating that the ruling would indicate that this is not allowed under the law.
Correct.
All right, then, the next item, 1416, is a conditional no contest plea of cancellation and bond claim for a license that was surrendered back in December.
Cancel and bond.
Commissioner Ford,
Cancel and bond.
Chairman Bradley.
Cancel and bond.
Next items, 1417 and 1418. It's a $3,500 conditional offer to two proceedings.
I'll accept 3500.
Thank you, Commissioner Fan. Commissioner Ford,
Talking about it.
3,500 accept.
Chairman Bradley.
Accept.
Next is 1419, is a $2,000 conditional offer.
2000 accept.
Commissioner Ford,
2,000 accept.
Chairman Bradley.
Accept.
Next is 1420. This is a new package store application.
This will be a bulletproof store. The location was not previously licensed. It's a store with one employee. Principal will manage full time. The applicant is the manager of a liquor store already in the Bronx and will keep that job as well as manage this place full time. I don't know how that works. There are two protests. The store is going to be 1,100 square feet. 600 square feet will be retail. The customer space will be 150 square feet, and the rest will be storage, presumably. The closest store is 0.1 mile away. There are 5 stores within 1 mile. And there are apparently 8 stores within a radius of 1.6 miles. That's it.
All right, Commissioner Fan, are you ready to vote?
Yes, this store is really quite just down the street from another one. And that store is doing declining numbers. There are just too many stores. As Chairman said, 5 stores within 1 mile. I don't see why we need more stores in the Bronx, so I'm gonna say no. Vote to deny.
Commissioner Ford,
Yeah, this would be the only bulletproof store amongst this cluster of stores that we have. Even though one of the closest didn't respond, but we just opened one up in 2019. I just don't know that I see there's a need based on the numbers and everything else for a bulletproof store in this area. So I'm going to vote to deny.
Chairman Bradley.
As Commissioner Ford pointed out, it's a bulletproof store. There's 5 stores within a mile. There's no evidence that the demand for alcohol is up. The population in this area is stagnant, and the closest store is about just over 500 feet away. And is non-bulletproof. So I don't know what public convenience and advantage a bulletproof store would add to this area at this time. So I'm voting to deny.
All right, the next item we have is 1421. This is a new package store application. I would note that so late last night, we received a email from the applicant's attorney requesting that the matter be held over. The attorney claims that they now have something indicating that the one city councilman who is in opposition is now withdrawing the opposition and wants time to submit that documentation.
That's fine. May 26th, is that enough time?
It sounds as though they just need time to get it to us. So I would assume so.
May 26th.
Commissioner Ford,
It's fine.
Chairman Bradley.
I'm fine with that as well, but it's open for further opposition as well, I would assume, as if that comes in.
Yeah, everybody who was advised initially will be advised that the matter's been held over, and they'll have, until the Friday beforehand to get their any supplemental items in.
Okay, thanks.
All right, then, the next item, 1422. This is a new package store license.
This is a Buffalo or a Tonawanda package store in Erie County. It's not bulletproof. It's a liquor store with no employees, principal to manage. The principal has no experience and will be full-time manager at the store. It's 1,200 square feet. 840 of that is retail. There are no protests. 1.1 miles is the closest store. 2.4 miles. There are 4 within 2.4 miles. 3 of the 4 closest are not bulletproof. 1 is bulletproof. And there are no protests, if I didn't say that already.
All right, then, Commissioner Fan.
Commissioner Ford, what do I need to know about this town?
It's a pretty densely populated bunch of neighborhoods in this area: Sheridan, Elmwood North, Kenmore. I'm going.
I see healthy growths. What do you think?
Yeah, I think there's a little bit of a COVID bump here with their sales, no question about that.
Yeah, I know, but
We see that everywhere. And the closest store, 6,400 square feet, and they're only going to be where did I see it? 840 square feet retail. So looking at the walkability of it all in that area, I'm going to vote to approve this.
Okay. I vote to approve as well.
Chairman Bradley?
I'm going to vote to approve as well. It's a relatively small store. It's not bulletproof. And the sales of the 4 closest stores, there definitely is a COVID bump in them, but they also were showing relatively increasing sales before that as well. 3 of the 4.
And there's no protest.
All right, the next item, 1423, is a new package store license application.
So Westchester package store with no employees, principal to manage. Principal appears to not have any experience. It's not bulletproof. The location was never licensed. There is 1 protest. The closest store is 0.1 miles. There are 5 stores within 0.6 miles. This is not bulletproof. However, the 2 closest stores are. No, I'm sorry. The closest store is not bulletproof. The second is bulletproof, and the 3rd, 4th, and 5th are not bulletproof. The opposition says there are 8 stores within a 5-mile radius.
All right, with that, Commissioner Fanny, you ready to vote?
Sorry, just give me 1 minute. I just want to look at the map really fast. All right. Yeah, the applicant is changing his career from being a foreman to this. There is a store that's close by, but I feel like this store is on Route 9 and perhaps would be more convenient. I'm gonna vote to approve.
Commissioner Ford?
They must be feeling pretty optimistic about this because they already have a really nice neon sign on the place. It says Rodriguez Wine and Liquor on page 40.
Not a good idea.
Yeah, it's not really the way to go about it. But again, it is a very small store, only 600 square feet, devoted to retail. Another store, the closest one, has 3,500 feet with 2,000 square feet of retail. Even the one that's only 500 square feet of retail is doing 1.5 million last year, still over 1 million before pre-COVID. And 2 of the others didn't respond. So I'm going to vote to approve as well.
Chairman Bradley?
I'm going to vote to deny, although it was close. The closest store is, just over 500 feet away. There's no evidence that the population's increasing. There's no evidence that they're providing any products or services that are not being provided by the other non-bulletproof stores that are all within or just over half a mile. And while it is a small store, there's 8 stores within a very small radius of a driving community, so I'm voting to deny.
The next item I have is 1424. It's a new package store license.
It's a Queens package store, 760 square feet, 570 will be retail. It is not bulletproof. It's a store with 3 employees and the principal to manage. The principal is currently employed by a C licensee that I believe is right next door.
The manager of the C license.
She's the manager of the C licensee. That is right next door. The closest store is 0.13 miles away. There are 4 within 0.37 miles, all of which are, the 3 of the 4 closest are not bulletproof. I don't think we have an indication on the 4th closest. There are 4 protests. There were also 3 people supporting her application. One is her landlord, one is her employer, and another appears to be a neighbor. The NYPD also sent in a letter of no objection, which I don't think says a lot. The opposition says there's 4 stores within 2,000 feet of each other already. They also indicate she has inadequate funding. She's invested $15,000 and already spent $10,000 on renovations. I believe that's correct, is it?
Yeah.
This was not previously licensed. The rent is $4,000, which means up front she would have to pay $4,000 a month, which means up front she would end up paying $8,000 of her $10,000, which means she's buying no product because she also has a rep who she paid as well. She wants to donate, which I don't even know if this is legal. She wants to donate $1 per every bottle of wine she sells to local charities. I guess that's a carrot for us, but is that legal?
Since she's donating it, I think it probably would be, but I don't think it's relevant to the public convenience and advantage analysis.
No, I don't think it is.
I would also note that the objection includes the notation and a photograph that the C licensee that is next door to this premises is using the premises as unlicensed storage without a warehouse permit, and the applicant is the manager of that C licensee. So I guess the opposition is saying that she's already demonstrated a disregard of ABC laws. The applicant says that the closest liquor store is over 700 feet away, which is, quote, not within walking distance, end quote. I looked, it's 2.5 blocks from the other store.
All right, with that, then Commissioner Fan, are you ready to vote?
Yeah, I'm gonna vote to deny.
Commissioner Ford,
I'm going to vote to deny as well.
Chairman Bradley.
I'm going to vote to deny. I don't see any public convenience and advantage, but I also think I question whether she's the actual owner of the store, given the lack of investment, as well as the fact that it's going right next door to her employer's building.
That's right. Tom,
All right,
give me 2 seconds.
all right, we'll take a brief recess. Okay.
All right.
All right, Adam, are you still with us?
Yes, I am.
Okay. Commissioner Ford, Commissioner Ford, are you all set to get going?
I thought I hit unmute. Sorry about that. Yes.
All right, we're all set then. Okay. The next item is 1425. This is a $1,500 conditional offer.
I accept 1,500.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
Next item, 1426, a $6,000 conditional offer.
6,000 accept.
Thank you, Commissioner Fan. Commissioner Ford,
6,000 accept.
Chairman Bradley.
Accept.
1427 is a $1,500 conditional offer.
1,500 accept.
Commissioner Ford
1,500 accept.
and Chairman Bradley.
Accept.
1428 is a $1,500 conditional offer.
1,500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1429 is a $1,500 conditional offer.
March 12. I'm going to counter at 3,000. This was 130 people inside. About double the allowable capacity.
Commissioner Ford,
I was at 3,000 as well.
Chairman Bradley.
100. I'll go to 3,000.
1430 is a $5,000 conditional offer.
5,000 accept.
Commissioner
Accept.
Ford.
5,000 accept.
Chairman Bradley.
Accept.
1431 is a $1,500 conditional offer.
1,500.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1432 is a $1,500 conditional offer.
I'm at 1,500.
Thank you, Commissioner Fan. Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1433, a $1,500 conditional offer.
1,500 accept.
Commissioner Ford
1,500 accept.
and Chairman Bradley.
Accept.
1434 is a pleading default on 2 charges.
1,500 accept.
Or not, this is a
Oh,
default.
sorry, I'll take 1,500.
Okay. Commissioner Ford,
1,500.
Chairman Bradley.
1,500.
1435 is a $3,000 conditional offer.
I'm gonna lower this to 1,500.
All right, Commissioner Ford,
I'm at 1,500 too, 45 years in the business.
Chairman Bradley.
1,500.
1436 is a $1,500 conditional offer.
Take 1,500.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1437, a $2,000 conditional offer.
2,000.
Commissioner Ford,
2,000 accept.
Chairman Bradley.
Accept.
1438, a $1,500 conditional offer.
1,500 accept.
Commissioner Ford,
1,500 accept.
Chairman Bradley.
Accept.
1439, a $5,000 conditional offer.
1439. Oh my God, I don't even have that. I'm sorry, Tom, you've got to skip that one. I got to go back.
Okay.
I had a printing mistake over here.
No problem. 1440 is a $2,500 conditional offer.
I'm gonna lower this to 1,800.
All right, Commissioner Ford,
I'm going to accept.
Chairman Bradley.
I'll lower it as well, same amount.
1,800.
Yep.
You got me. I'll go along with that too.
1441 is a conditional offer of $7,500.
I can't accept this. I do not accept this.
Did you want to make a counter offer or just send it back to counsel's office?
Does Gary want it back?
Well, it's coming back no matter what, unless you give him a counter offer that he accepts. So, well, I don't know what the other votes are, actually. I shouldn't say that.
Well, I mean, I think she's right because it's obvious that the cop almost went there every other night and must have told them to tone it down, and it didn't happen. And they kept playing outdoor music that they weren't allowed to have.
It would help to frame the potential for a hearing if the board gave the licensee an indication of what they think the proper penalty would be. So it would be helpful if there was a counter offer.
I'm gonna counter at 15,000.
Commissioner Ford,
I was going to counter 10.
okay. Chairman Bradley,
I'll counter at 15 as well.
right then, next item is 1442. It's a pleading default to 2 charges.
I'm at 15.
Commissioner Ford,
1442, 1500, yes.
and Chairman Bradley.
1,500.
1443 is a $3,500 conditional offer.
Unlicensed security guard. Punch a person in the face. Not supposed to have security guards. I'm gonna counter at 5,000.
Commissioner Ford,
I'll accept the 3,500.
Chairman Bradley.
I'll accept. Although I agree with Commissioner Fan, but I'm gonna, in the interest of convenience, I'm gonna get rid of it.
1444 is a $2,500 conditional offer.
I will accept 2,500.
Commissioner Ford,
2,500 accept.
Chairman Bradley.
Accept.
Next item was 1445. It was held over from the last meeting. However, yesterday we received an email indicating the applicant's attorney indicating that the application is being withdrawn. Next item is 1446. This is a request for declaratory ruling.
All right. Yeah, so this is a declaratory ruling that seeks the board's determination that an internet platform for a third-party provider is legal. The platform would be an internet site where on and off-premises licensees could advertise products and promotions, and consumers would go on there and put in information that reflected their geographical area, and would then be shown advertised products and offerings that would be suitable for them based on their geography. They could then purchase a credit to buy the food and beverage at these locations, or maybe it's just beverages. I don't know, either way. And then they would get this credit and they could redeem it when they got to the retailer. And then once redeemed, the platform would release the funds that they had collected and held in a segregated account to the retailer. And they would subtract the fee, which would not exceed 10% of the sale. So in such cases, the key question is whether that's an availing, either based on the way in which the third-party provider is compensated or on whether or not they're controlling the business. For example, are they selecting the products or the prices? Are they so in control of the money, et cetera, et cetera? The declaratory ruling here requests the representation is made that the platform will play no role in product choice, price, or any of those things, but they will have a segregated account. The members received an objection from Drizzly, which is a third-party provider for off-premises alcoholic beverage purchases. Drizzly boldly claims that approving this method would go beyond or contradict prior limitations expressed in earlier declaratory rulings of the board, cites a whole host of them, and makes some general conclusions about what Drizzly argues to be bright lines, including a bright line that says that the way in which third-party providers can be compensated is different for on-premises licensees, for doing business with on-premises licensees and doing business with off-premises licensees. They say off-premises, no percentages are permitted. I looked through all of those declaratory rulings, and not a single one states expressly or impliedly that there's any such distinction between on-premises and off-premises compensation. It is true that the declaratory rulings that are out there that involve third-party providers that are dealing only with off-premises licensees, the methods proposed in those declaratory rulings involve flat fees. So I suppose that Drizzly is coming to the conclusion that that's all that would have been permitted, but those declaratory rulings don't say that. In fact, going back to 2011 and then 2013, the way in which the board has approached these issues has changed to some extent in time with the way technology is changing, and technology has changed. So, for example, there were some early rulings in 2011 where there seemed to be where one of the facts that the board reported, or that the method reported, was that the third-party provider was arranging for a mix of food and alcohol to be purchased, which Drizzly concludes means that that was somehow required. And yet a few years later, in the Thirst for Night ruling, that restriction seemed to be abandoned. And in fact, in that ruling, which approved a third-party provider like this one, there was no requirement that food be purchased. It could be all alcohol that was purchased through the app that was at issue in that case. In fact, that's one of the points about Drizzly's objection, is that they argue that the reason that there should be a difference between off-premises and on-premises licensees is that this kind of requirement for food, and that a percentage deal would mean that a licensee was turning over a larger percentage of just alcohol to a third-party provider as opposed to some kind of mix between food and alcohol, which would potentially make the percentage share less of a de minimis amount than otherwise. But again, Thirst of New York didn't make that distinction. I don't think there's the bright lines that are suggested by the Drizzly objection on that issue is a valid one. In fact, all of those declaratory rulings say they apply only to that particular requester. And while I understand that people in the industry try to draw conclusions from that, I'm not sure that means that the board is somehow constricted based on what one party might interpret those rulings to mean. Drizzly also points out that there's an issue with them holding the money in custodial accounts. That's something that the board has not permitted for the off-premises entities, or the entities that do business with off-premises only. But they admit that was permitted in the double L case, which involved on-premises. Again, I don't see anything in the declaratory rulings that suggests a reason for that distinction that Drizzly is drawing. Drizzly also cites the Total Wine disciplinary case and says that in that case, the board sustained a charge for availing where gift cards were being sold by a third party, and tries to equate that to the current declaratory ruling request. There's actually differences that are not noted in that in Drizzly's letter. I'm not sure how well the board members remember the written opinion in the Total Wine gift card case. I happen to be very familiar with it because there's a lawsuit that we just briefed on that case, Article 78, challenging it. What happened in that case was that Total Wine, which had accepted gift cards in its store in New York that were handled entirely by a third party, RSSI, failed to introduce enough evidence to show that this third party was actually sending the money to Total Wine for the price of the gift cards. There was an evidentiary issue in there that's not present here. We're assuming that the requester will send the money to the retailers when they give them alcohol. Also in Total Wine, there was a common ownership issue that had an impact on that situation. RSSI is owned by the same person who owns the Total Wine in Long Island and also owns all the other Total Wines where these gift cards are being sold. So there's an independent business issue in that case. There's also the question of unredeemed gift cards in the case of RSSI and Total Wine. Unredeemed gift cards would essentially just be kept, the money would be kept by RSSI, whereas here there's a provision for what happens with the unredeemed gift cards. The customers have an account on this platform that they can continue to use the money for to buy anything, buy alcohol in some other place if for some reason they don't use it for this place. The principal objections that were put in here suggested that bright lines have been drawn when really none have. I would also note that the draft proposed third-party provider advisory that's being released today, if it was in effect, this arrangement would be legal under that advisory, which I believe, which doesn't make a distinction between on-premise and off-premises licensees, and says that 10% would be considered de minimis if it's 10% of the total revenues of an operation. And here we're talking about 10% of particular sales that are made through their system, which would only become 10% of the total revenues if that was the only way in which participating retailers did business, which I think is highly unlikely. So I wanted to address that because we did get a response from the requester that covered some of that, but a lot of this is also covered in our third-party provider advisory. And with that in mind, I'll stop talking.
Commissioner Fan, are you ready to vote? You're muted, Commissioner Fan.
Hi, I'm sorry. Can I just clarify something? So what happens to the money in the event that the credit doesn't get cashed in at the store?
The declaratory ruling says that the request says that, actually the request addresses the issue of what happens if the person doesn't get in there while the promotion is still in place. And the answer is that the money doesn't get pocketed by the internet platform. It remains available to the consumer who sent the money in to be used for any other promotions. I don't know if there's a provision in their method for what happens if the customer decides that he doesn't want to use it anywhere. And I suppose if the board is concerned about that, you could put a proviso in there that there needs to be something in their business plan that makes sure that they don't hold the money in that circumstance. Although, to be honest, in that circumstance, no alcohol has been purchased, so it's not like they are getting the benefit of a purchase of alcohol that they're keeping. They're really just dealing with customers out in the street.
But they point out in the
Yeah,
request.
that's why I was, sorry, that was my next question, is at what point do you decide that that's actually selling alcohol? Is buying a credit to claim alcohol the same as buying alcohol, or no?
Well,
Because-
this is while there's a custodial account held for each retailer, the transaction is not intended to be you're buying it from me. You're buying it from the retailer, and the platform is supervising the transfer. And that type of arrangement has already been approved by the in a prior declaratory ruling. So I don't believe
That they're allowed to hold the money. But but I guess maybe we should have a requirement that in the event that the credit doesn't get used at the store after a certain amount of time, I mean, it either needs to go to the store or it needs to be refunded to the consumer. The platform is not allowed to keep it, right? Or are they allowed to keep it because no alcohol was actually sold?
Well, I mean, they have one situation that's very similar to that is they don't address in the request credits that have been abandoned by the customer.
Right,
So
that's
say
what I'm
they-
asking.
Yeah, it's a similar situation to not being able to buy what you want because it's already gone when you already purchased the credit. So I think we can definitely require them to refund it. I don't think that's a problem.
Yeah, and they seem to be very flexible. Well, look, you can enter a declaratory ruling based on any set of facts. So I think it would be useful to them, if that's the only issue we have with this, to say we would consider this legal as long as you create a reasonable process for the return of funds that aren't used to the consumers.
For whatever reason.
Yeah.
Within some reasonable amount of time, would you say?
Sure.
Say within a
Yeah,
year?
I don't know.
Within
But
a year.
should it go back to the consumer or should it go to the store?
Well, if they didn't buy anything, it can't go to the store.
If they didn't buy anything, it can't go to the store. So it goes back to the consumer? Okay, I don't know if the platform is okay with that.
Well, then if they're not,
That is what was done in the Double L Corp declaratory ruling. That was in their protocols, I believe.
Okay. That
So
So there's
after,
precedent for that requirement. It would be
So-
okay for the board to hold that.
okay, and so how would we enforce that?
well, under the advisory, should that get passed, we would have an ability to because it would be a contract that ended up here. But
Well, I guess that's the point. The point is really what we have jurisdiction over is the sale of alcohol. The concern here is whether a third-party provider is availing somebody else's license. And to be honest with you, even though there may be a concern about the propriety of a third-party provider holding on to the odd case where a consumer doesn't show up and actually get the alcohol they had purchased in their store, that doesn't really have an impact on the issue of availing. It's perhaps not fair, but the third-party
No,
provider
it goes
is
to the issue of the 10%, right? Oh, but you're saying that because no alcohol was actually sold. Well, that's what I'm go
Right.
back to the same question is, do you consider the sale of the credit the sale of the alcohol, or it's when they actually pick up the alcohol that's when the sale happened? Because that's not when they paid. I think the sale should be when they actually paid. Like that's a definition of a sale, right? So in my
It
mind,
depends-
they
it
already
depends,
paid for
but
the alcohol and they didn't go pick it up. And so in the event that that's the case, then I don't know. I don't even know if it makes sense to go back to the consumer. I really don't know.
no, I think in that scenario you're correct. But what about the scenario that they happen to oversell?
right. They could oversell, but there's also
Meaning that there's a credit bought, the consumer goes to use the credit, but can't because whatever sale was going on was also going on the street, and people came in and sold out and bought out all the products, and the liquor store shouldn't keep that money.
Yeah, look, this is actually an issue in every third-party provider situation we've approved, like Instacart, for example. Instacart is booking sales when the consumer makes the payment to Instacart. There's certainly a percentage of sales where that goes through, and the alcohol that gets delivered is either improper or insufficient, and the transaction needs to be reversed. And we don't require, we don't have rules in the declaratory rulings that walk the third-party provider through how they return the money. We don't have that. Presumably, we're leaving it to the consumers to make sure that they only do business with Instacart if they know that they can get a refund if they don't get what they paid for. And I don't know that we necessarily need to get into that unless you want to.
No, but I'm just saying, if the goal is to enforce it 10% only, less than 10% only, then to leave this out there is not actually enforcing it. It's selective enforcement, right? I mean, it's saying that, well, if they don't cash it in, then we don't care, because then at
No,
that point,
I actually think those are two completely separate issues. The issue of 10% as opposed to a flat fee is whether a third-party provider has control over a licensee because it's getting a percentage of the revenues, and we view this as a de minimis amount. So I think it's a discrete issue from whether this business plan should, on its face, before it's approved, have a procedure for returning money for unused purchases.
Okay, so what would be fair? Would it be 1 year or 2 years?
that's fine.
mean, and is there going to be a reporting mechanism of that, or is that just like?
Well, but here's the thing: they're not under our jurisdiction. If they don't return the money, we're powerless to do anything to them.
Right. Yeah.
And I guess the point about our lack of jurisdiction shows why this is not really the issue that's in front of you. The issue that's in front of you is whether or not it's an avail.
But the jurisdiction, we don't have jurisdiction, that's correct, but we do have it right now. And if we approve a method of operation that requires them to run a return situation on the situation she's talking about, and they're not doing that, then anybody using their service is violating the law.
Correct. We would have to charge their retail customers, the retailer licensees they're doing business with, because they're using a service that's not complying with a method of operation we approved. But I don't know what we would charge them with, to be honest with you. It's not availing.
Well, if there's no return.
I think that just because I don't think they need to start this business in the next 2 weeks. Maybe it's worthwhile to let the lawyer and the applicant to decide how they want to address that. I think it's just one last piece that they need to clean up.
Well, they can say how they want to address it, but that will not address the other question you asked, which is how we will enforce it. We will not be able to enforce it. And we can't enforce it for Instacart, and we can't enforce it for Double L, which is one that was already approved. You know, as a matter of fairness, I agree with you. As a matter of kind of our purview, what they're asking for is whether they'd be tripping over the law that we have by operating this way. And I think the answer.
Okay. Sorry.
No, but I think, but how is it not availing if they're taking payment for alcohol, that they're not sending to the licensee and the product's not getting delivered? The person is buying alcohol. They're taking the revenue from that alcohol, whether it's 10% or not.
That's an issue in Instacart too.
I think you could charge them with availing if what
it's an issue with Drizzly.
If what we approve says you have to return that money if there's no product, and they don't do that, and they keep the money for the sale, not their 10%, but they keep the 10% plus the revenue, then I think it is availing.
For that particular sale.
Yes, if they're not following
if we get a complaint from a consumer that says, I use this service, then we could charge the retailer for
Availing for that sale.
that sale, which will be
Will have nothing,
$10.
and it'll have nothing to do with the 10%. It'll have to do with the violating this
right.
and
Because a third party used their license to induce them to make a payment for something they never got.
right, and then kept the payment.
So that would be the way we would enforce it, but it would have to be based on a complaint, not on getting some report from an entity that's
Right.
not under our control.
But we can put it over and have them answer the questions. I don't disagree.
Yeah, I
with it.
think it's fair to ask them to clean up. They must have they must have an idea. There's a preference what they want to do and how they plan to do that. Because
Yeah, they probably have something in place already. You're right.
It may be helpful though for the board to discuss further whether they have any other issues with the declaratory rule, and just in case there's anything else that the requester may need to consider.
I don't. I mean,
really,
I think it fits squarely in what we're putting up in an advisory. So,
It is.
but I think her issue that she raised, I would like an answer to that.
Commissioner Ford.
I'm fine with that, and it doesn't hurt to get a little clarification on that. We've gone this far. And with your conversations today, they may have some other things they might want to bring up, so.
Here to help.
And you do a heck of a job too.
Are we all good holding it over to May 26th?
Yes.
May 26th, thank you.
Okay. The next item on the calendar, items on the calendar, 1447 and 1448. This was held over from the last meeting. Request for reconsideration.
And they submitted CNC of just cancel and bond, right? That's what I see in the supplemental.
Yeah,
Yes,
that's why we put it over.
Right,
Because
okay.
the alternative would be a revocation, which didn't seem to be fair under the circumstances. So
Okay,
you'd have
so
to,
I'll accept cancel and bond.
Well, it's a recon.
first you have to say you'll
Oh,
take
I
the
will
reconsideration.
reconsider.
All right, Commissioner Ford, you going to reconsider?
Yes.
And Chairman Bradley?
Yes.
All right, on reconsideration, respect to the penalty, Commissioner Fan,
I will accept cancel and bond.
Commissioner Ford,
Accept, cancel, and bond.
Chairman Bradley.
Accept.
Next item is 1448A. This is a CNC of $10,500. This license has been summarily suspended since December.
I'll accept.
Commissioner Ford,
I'll accept as well.
Chairman Bradley.
I'll accept.
Commissioner Fan, are you ready?
Right?
Right, Commissioner
Can
Fan,
you
are you
just give
ready?
me one moment? Give me 1 moment, Tom.
Okay,
Just give me 1
yep.
moment.
Oh, what
No,
was
what's
that?
that, Tom?
1430,
1430.
39.
1439.
Given what we've done all day today, I'm gonna lower this to 3,000.
But then, so Commissioner Ford,
I'll go to 3,000 as well.
Chairman Bradley.
3,000.
All right. Chairman, I have no other items on the calendar. Do you have anything else?
No, thank you all and have a good rest of the week.
Thank you.
Thank
with
you,
that-
Chairman.
With that,
Bye-bye.
this meeting is concluded. Thank you.